I'd like to open the meeting of the Planning Board for March 26th. The first item on the agenda is the three zoning proposals. We'll do them one at a time. So we'll do the presentation, discussion, comment, and vote one at a time. And the first one's going to be zero lot line, which I'll turn over to Carol.
The ordinance in front of you is a continuation from January. You all had a discussion and public comment at that point, and there seemed to be some confusion or just not clear understanding because there's a lot to the existing ordinance and then some new twists on the proposed changes. So there was a request to have a more informal conversation with neighborhood groups and identify and send out notice so that a broader spectrum of city residents could come to that and understand it better so that there was information would be shared with a broader portion of the community. So we had a workshop. Our office sponsored a workshop that was held March 17th at Bridge Street School. There weren't a lot of people there, but we had, maybe 20 people or something. And it was a good conversation. I think that there was some better understanding among the people who did attend. So now we're back in the public hearing. We went through the ordinance in detail. It was really just a question and answer session. So I don't know if you want me to go through the changes again to clarify or to go and explain the changes, but again, the ordinance is in place. There's some recommended changes to simplify things for those applicants, for the most part, who would have applied for zero lot line single-family homes, and it does only apply to single-family homes, and it's a by right application process to create a lot that has a zero side setback. The changes simplify some of the original requirements because we are finding that people, for instance, who wanted to build a house next to their existing home didn't necessarily want to put a site impervious fence and wanted to put windows on the side that share the zero side setback, and the requirement was that they would have to come to the planning board in order not to provide those things. So this ordinance eliminates that requirement. And there were some other inconsistencies relative to parking location and the number of parking spaces, inconsistent with other sections of the ordinance. So there is a recommendation to remove the criteria relative to parking in the setbacks.
Because it's repetitive, duplicative.
Right, and it's slightly different than what's the other section in the parking section itself, where it talks about parking in residential districts. The one change that I think got the most discussion was the issue about creating a zero lot single family house for an existing structure that abuts other residential structures and lots that are not zero lot line, and that someone could apply to essentially convert their lot to a zero lot line and thereby expand their existing home towards a side setback that they otherwise wouldn't be able to do with the 15-foot restriction at this point. And that, as proposed, could only happen if there's agreement by neighbors on both sides of that property, the non-zero side setback side as well as the proposed zero side setback side, and agreement on the design of that addition that comes closer to the property boundary, and that those agreements would be recorded at the Registry of Deeds before the prospective applicant came to the city for a building permit to make that addition. Are there any questions about the specifics of the ordinance or issues that we should?
So there is currently no requirement for notification of anybody if you want to create a zero lot line lot. Is that correct?
Right, the only notification would be if you wanted to eliminate one of the required elements like the fence or add windows, then there would be notification, but that would be potentially after the structure was already built. Or certainly before the
And
lot
that
was approved.
notification would have to happen because now you have to come to the planning board, but there's a public hearing to get that matter resolved. Is that correct?
Right,
So the notification is linked to the public hearing, not all by itself.
right,
Okay.
right.
And I have a second question is, so why does on the non-zero lot line side, why do you want to get the sign off of the person who lives there? The logic which occurs to me is because they are less protected under the new proposed language than under the existing language, where you gotta have twice on their side what you have on, which you would be able to have at a minimum under the new proposal. Does that seem right?
Well, the existing, if you're a conforming single-family house lot, now you need 15 feet. So if you're an existing structure, you need 15 feet, and if you wanted to expand, then you have to stay within the 15 feet. There would be no provision, now there's no provision to create a zero lot line structure from an existing structure and parcel. So it's not the 30-foot setback. I think that it's just the neighbor most proximate probably to the change on that parcel that's going to happen.
Just make sure this issue of the agreement from the owner is only the owner who's on the zero lot line.
Okay, it's only one neighbor. Okay, I misunderstood, okay.
Well, it says on both sides of the property in number 3.
Which must mean between the two houses, in the two structures in question, not the third neighbor.
No, I mean, I think maybe it's not clear, but certainly, because this is the zero lot line side house must abut
Okay.
the property owner who agrees to design covenants. The design
Okay.
covenants cover the entire house.
Okay.
Oh, the design, okay.
Yeah.
So then that was my misunderstanding of that
So
language.
it does not apply to the non-zero lot line of butter.
Because they would deal with the same setbacks that they would be expected to deal with in that district.
Okay. But now, don't you have to have twice
You do.
what, so for the planning board to grant you a special permit, you have to have twice the setback on the non-zero lot line side.
That's correct.
So and one could make an argument perhaps that those people are also suffering by this change.
Right.
And perhaps should be notified.
But let me just clarify, there isn't a special permit now for the creation of the lot.
Okay.
So there wouldn't be a notification. If someone, for instance, someone comes to our office to create a new lot, they own a large parcel and they want to divide it into 2 zero lot line lots. They just come to show the division of property into 2 conforming 65-foot
Frontage lots.
frontage
Yeah.
lots. And then when they come for a building permit, they just show that they have 30 feet on the very 2 outside side lot lines. And then the interior shared side property boundary
Can be
as close
zero.
as 0,
But
right?
so, is it not the case that then they do now have to provide twice the standard setback?
Yes,
So, okay.
right,
Okay.
right.
Yeah, we certainly change, from what the standards are now to what's proposed, you're certainly right, someone's house can get closer. On the other hand, if they didn't do a zero lot line, they could just build a traditional home.
Right, and be closer still, or be, where they're gonna be under the new proposed language.
Exactly.
Okay, great, thank you. So the language there is confusing about with the votes.
Right.
I mean, I suppose the first B takes care of it all, but,
And maybe if it said the design of the entire single-family structure or design of the changes to
Yeah.
the entire single-family home.
Both sides of the zero lot line.
Yeah, that's right, that's why.
I mean, one of the questions that did come up in the workshop was why someone perhaps in the rear might not be notified, because they might be equally,
Affected.
have an impact as the person on the side where the zero lot change is happening. So, you know, that was one of the issues that,
Well, is this going to allow them to do it by right?
yeah, it's allowed by right now, and the proposal is to be allowed by right. But then the one step would be that you get sign off from your neighbor and go to the building department and show that you've recorded covenants at the registry of deeds.
Yeah, but there's no a butter notification. I think
No.
Because
I think
now
it's the
the-
kind of thing that you really need a butter notification myself.
Well, but now, Randy, you have to own both lots.
Or, well, no, you have to get the neighbor to agree, right?
Well, currently, you have to own both lots,
I agree.
where the zero lot line is shared.
Okay.
The proposal is that you don't have to own the other side, you just go to your neighbor where you've got the zero, where you're proposing to move your structure or where there would be less than a 15-foot side setback, and get an agreement between the neighbor that you record at the registry, then you take that to the building department and say, we agree on the design of my new house or my new expansion, I'd like to pull a building permit. And that's the
Planning
extent of
department,
it. Yeah.
So, neighbors don't have any recourse? How do-
Well, just like now, when there is an appeal period, appeal of a building permit, or any decision by the building department can be appealed within 30 days.
But they're not gonna own it.
Right.
Well, I'll take that only because I have a follow-up question. So right now, does a person have to come before planning board to get that, so they can just build an addition right up to their neighbor?
They cannot build an addition, because right now it doesn't, you have to abut another zero lot line lot or open space. So you can't have two vacant, or two structures on two separate lots, and then in the middle, the lot, let's say, is vacant. You can't come in and create a zero lot line between two existing single-family homes now. You can only create it if it's next to another zero lot line structure or open space.
I think, I think we're all getting confused on that one point. I think, right now, if you are the owner of both lots,
Yeah.
you have control of both lots, you can create a zero lot line without ever coming to the planning board. You can do that by right,
Not now.
right now.
Right.
So if you have both sides, if you control both sides of the lot, it's yours. The only reason you'd have to come to the planning board is if you didn't want to put the fence up, or if you wanted to put windows on the sides of the building that abut the zero lot line. That's the only reason it would come to the planning board now.
Right.
And the change is, you can do it without control of the second lot if you get sign off from the owner of that lot.
Right.
Which means two existing structures, you want to do an addition to your structure that goes up to the lot line. That's probably where we'd see it the most, is people doing additions. Otherwise, a builder would have to have both lots to start with. Is that,
Right, I mean, there may be some situations where there's a leftover parcel that's 65 feet of frontage.
or somebody carves off a piece of land
Right,
from land,
right.
that lot that they already.
Right.
Oh, sorry, Mark, George?
So I'm just trying to understand the impetus behind this whole discussion. Over the past couple of years, because of the whole infill situation, folks have been coming to the planning office saying, I want to expand my home. Because we haven't seen any of these come in front of the planning board in 10 years. I'm trying to understand where,
Well, the ordinance was adopted in 2001, I think it was, early 2000. And since that time, the zero lot line projects that have come forward that I have seen because they've gone to the building department or they've come through the approval not required process to create a lot that's 65 feet of frontage but meets all the other dimensional requirements. There have been instances where applicants, and what you have seen are applicants that have come before you, and I'm going to pull this one out because this came for you for site plan on Nonatuck Street, where the person created a zero lot line lot here. This was an existing house. They carved a new lot out so they could build a house in the rear. They didn't want to put a fence on the zero lot line property boundary. So they came to the planning board just to get approval to eliminate that requirement. So this isn't the only occasion where this has happened, or people have come to our office and said, well, I don't want to build a fence because I'm going to design it such that my house is back here. Why should I have this big fence? So the impetus for that, most of the changes in here is because we want to eliminate the time, the money, and the process it takes for people to come to the planning board just to deal with a situation where if it's their own design and they figure out how to lay out the lots, why should the city get involved in telling them that they need to put a fence in if they don't want a fence, or windows if they want windows, they should be able to do that. There is an applicant on Round Hill Road who's under construction now with a zero lot line property who is waiting to see what happens with this ordinance, because otherwise they'll file to the planning board and say, I don't want to put a fence up because, again, I set my house back, I wanted to put windows in such and such location, and I don't want a fence. And so that's another situation. We've told them, you know, maybe wait it out, because who knows what will happen, but you might be able to save yourself some money and time if you just wait another month or two or whatever. So those situations have come forward. The piece about, in that situation, it was an owner who had an extra land and they wanted to carve off a second lot. So that is, they conformed in all other aspects to the zero lot line requirements. The other piece about allowing the creation of a zero lot line out of an existing single family house is new, and it's really just about addressing some instances where, well, actually there's the other piece about dropping the 30-foot setback on the non-zero lot line side also has to do with requests that we've had to create lots, but they don't meet the 30-foot setback on the other side, and it's twice as much as all the setbacks in most of the districts in the city. So that's another piece. But the other piece of it is people who may want to add on to their homes, but they can't. And to the extent that we're allowing zero lot line for new lots, just because people control both of them, doesn't necessarily make sense not to allow other people who might want to expand onto their homes and who have agreements from their neighbors. You know, it's sort of the next step in the evolution towards allowing additional single-family homes to be developed or to be expanded upon in the city.
I had two comments that I could. One is in terms of the issue of the owners. One concern we had is, you know, we right now have this process where you don't need a finding if you know that the owners to sign a petition to agree to it. And the problem with that is when your neighbor comes knocking on your door and says, you don't mind if I really build this, a lot of people feel pressured into doing it because they don't have any command of it. So that's why this goes the extra step of saying you really have to be selling these. You know, you have it's a document recorded in the registry. Your bank has to subordinate it. So the idea is to really make sure the owner is really comfortable with it. And that theory being the next door neighbor is the one who's going to mind the most. If they don't mind because maybe the homes are offset or it's design control or whatever private arrangement they do is not necessarily a greater public good for it. And then the other thing, frankly, is just a loophole which we realize, which as far as I know, no one's taking advantage of. But right now you get zero lot line development if you own both lots. You could, if you had a really good attorney, you could do a fiction, a legal fiction, where you sell your property to your neighbor sells you their property for $1. You come into a zero lot line development, and the next day you sell it back to your neighborhood value. We're really careful, you have good lawyers to make sure it's safe, but that's legal to do. And so if in essence you can do that, why not skip that step transaction and say, look, if both parties really want this, why do we object?
George, you all set? Mark?
You're talking about the next door neighbor is the one most affected, which I agree with, but it would also seem the rear abutter would also be affected, which you said they spoke about that at the,
Someone raised that as a question as to why wouldn't the rear abutter be notified or sign off on it?
something in the language in 3, wouldn't it say design covenants that control the design of both sides, or where does it say? Oh, it's instead of both sides of the property, change that to all sides of the property. So people in the rear, you're talking about knocking on the door and asking,
Yeah.
you know, is that, I would think if you need permission from Mr. Smith next door, you'd want Mrs. Johnson behind you to.
There's definitely logic to doing that, it's fine if you all wanted. The reason we didn't is because right now, if you own both properties, you don't need the permission of the property. So we're sort of trying to keep it parallel, but I still understand where you're coming from.
And if I may, you're also encroaching on your side lot line neighbor and not your rear lot line neighbor.
Right, you still have to maintain.
So they
Right.
would be the more aggrieved of the two, presumably.
Right.
Randy?
What about item D there, what's the map there?
Not only what's the math, but it's like a
What's the
rider
math?
to some other spending bill. How did it get in there?
Yeah.
Well, the idea
for a bike
originally,
rack.
let me go back. The idea originally, this is sort of go slow. The idea is
Yeah.
what makes places like California, Southern California look hideous, when they squeeze all these lots in, is you drive along Southern California and all you see is garages. And so what dominates the landscape in Southern California, because they've crowded these homes really tight, is garages. And so the idea of the planning board at the time is do zero lot line developments, allowing a little more development, but you gotta really make sure it's attractive. And so there'd be standards where garages had to be set back further than they generally are, or couldn't dominate, either it'd be twice as far back as they usually are, or couldn't be more than 25% of the front facade. Parking has to be a greater distance back. The reason for dropping parking is we have to do that elsewhere in the ordinance. And there have to be more trees than we generally require. So the idea is saying, we want to make, if zero lot line developers are getting more density, we want to make sure they're giving back and the projects fit in.
And that's not a change, that's the way it is now.
That's where it is now, that's correct.
But doesn't the number of trees depend on the size of the lot?
Well, generally, yes, not for these lots. So
Yeah.
You
this is
still
more
need,
than.
yeah, you still need 8,000 square feet of lot area for the lot. This is not 4 trees along the frontage, it's 4 trees total, 2 of them.
I know, I'm not saying it's too many trees, I'm saying it might be too few trees. If our ultimate goal is to have trees every 28 feet or whatever. I don't understand why, I mean, you're assuming the lots are gonna be small.
Well, yeah, the typical people are doing these to take advantage of 65 feet of frontage. So if they had 70 feet of frontage, they probably wouldn't bother with zero lot line. So for the most part, we're thinking about lots that are somewhere between 65 and 74 and a half.
Well, I don't like the ones where they probably aren't gonna do this.
What do you want to make the wording similar to the?
Well, I don't know. It looks to me like it's a solution and we don't really have a problem.
But it's also, that's the way it is today, so that's nothing we're voting to change right now. Karen?
Is there the possibility of having more than one zero lot line issue on a lot? And what if you owned, or you had neighbors on other sides of your property also who wanted to move, build other things? Or is this just one of these per lot?
Well, this is for the creation, it applies to a single-family house lot. So the single-family house lot would be a minimum of 65 feet of frontage and 8,000 square feet total. So yes, you could have, just like you got a standard 75-foot frontage lot on a street, multiple, right in a row, you could certainly do more than one single-family house lot.
You could do it in the back as well, depending on how big.
No, you still need frontage along the street. So each lot needs to meet the other dimensional requirements for layout so that you have the right amount of depth and width to that depth. so that you have a uniformity along the front of the street.
No, but I think Catherine's question is, could they do it on both sides of the house? And
Could they do it on
could
both?
you do it on all three sides of the house? When you have 0 lot line on more than one side of the house?
No. I'm sorry. No, it's about one side property boundary is less than the 15-foot side setback. And the other side has to meet the 15-foot side setback.
And
And
the
the
rear.
rear has to meet 20, and the front has to meet 20.
Okay.
And where is that stipulated? About,
It's in the table of dimensions.
So it's not in this language here?
Right, we haven't changed the dimensional standards, no, other than going from 30 feet to 15 feet.
Well, doesn't it say, while the opposite side meets the standard yard setback,
Right,
side yard setback, in the first sentence?
right.
Any other questions, or should we hear from the public? All right. Anybody from the public want to speak on this issue? Jerry has his hand up first, sorry.
Alex can go first.
No,
No,
go
go ahead, Jay. Age before beauty.
Used to like you. My name is Jerry Budger. I live at 127 Bridge Street, and I'm speaking as an individual this evening. I have followed this 0 lot line proposal process with great interest, as it is one of the first rezonings to come before city government since adoption of the sustainability plan. As there are likely many more rezoning proposals to come, it's important that there's comfort with the process to be used. My comments are addressed to this issue. My first concern is one I expressed at the last session of the public hearing, and it regards what I consider to be the lack of proper notification of affected property owners. When the 0 lot line proposal was first discussed, the Planning Department passed out a sheet with some 50 properties marked by red dots that they said would be the only properties affected by this proposal. However, at the recent forum, another Planning Department map was distributed, and it shows that all properties in zoning districts URB and URC will be affected by this proposal because it includes both new homes and additions. Excuse me. My concern tonight is the same as it was several weeks ago. It is simply that nobody has notified these property owners that there will be substantive changes in the zoning governing their properties. This is not the precedent that should govern consideration of future zoning proposals. Instead, we need a city policy requiring that notification of any proposed change in zoning will be sent to each and every impacted property owner and all abutters to those properties. This is essential because for most families, their homes, their most important and valuable asset. Is there anyone in this room who would like to wake up one morning to discover the city has changed the zoning on your property or the one next to you without your knowledge? This almost happened to me, and I was outraged that I didn't even get the courtesy of a notification. I realize the city has severe financial issues, but everyone involved with these rezonings, the planning board, the planning department, the zoning revisions committee, and the city council needs to collaborate to find alternatives and cost-effective methods of property owner notifications. Second philosophic change that concerns me is the attempt in this legislation to eliminate the right of property owners to be informed of and comment on changes happening in their neighborhoods. Currently, if you wish to build closer to the side lot line than the current 15-foot buffer, you have to seek a special permit. This means there's a public hearing where neighbors within 300 feet are notified and can have their say on the matter. Under this new proposal, you can get closer than 15 feet to your side lot line if you and only one neighbor agree it's okay, and he or she gives you an easement that's recorded. The difference here is that, unlike now, other nearby neighbors will not be notified of this closer encroachment to the boundary line or given any opportunity to comment on it. Two neighbors acting together and alone can forge a private agreement to make a major change to a neighborhood. I understand Councilor Reckman will be suggesting a modification of the proposal to require anyone seeking 0 lot line construction to notify all neighbors within the same 300-degree range as now required for a special permit. This would be a huge improvement and allow neighbors an opportunity to have input on the project to assure it fits with the existing neighborhood. Thank you very much.
Alex Giesland, 164 Riverside Drive. I
I don't have any objections to modifying the zero lot lines. The proposed changes make a lot of sense to me. My problem is the continuing incremental changes in zoning to the URB and URC without first resolving the issues of how the URA will fit the objectives of our sustainability plan. Through dimensional reductions, changes like zero lot lines, we've made it easier to build in the URB and C, and easier to build 2- and 3-family houses to fill in and increase density. Seems reasonable to me. We want to expand neighborhoods where people can walk to services and shopping. What doesn't seem reasonable is to exempt neighborhoods near our urban core just because they're labeled URA. There may be good reasons not to want more people living on Ward Avenue, or Hillside, or Bancroft, or James, or Dryades Green, but I don't see that rationale articulated in our sustainable Northampton plan. If people begin to view zoning as irrational, or worse, politically driven, it will be difficult, and should be difficult, to continue asking residents in the URB and C to welcome increased density in their neighborhoods. It's not only zoning. The Conservation Commission is directed to consider reducing wetland buffers for buildings in the URB and C. This is hard to justify while there are streets and neighborhoods close to downtown where even a 2-family house is not allowed. So I'd ask the council to table all proposed zoning changes in the URB and C until we have the recommendations from the Zoning Revisions Committee. The moratorium would allow for comprehensive and rational plan for implementing the vision of sustainable Northampton and reduce the chances of driving a wedge between neighborhoods. Thanks.
Adam Cohen from North Street. I want to repeat a concern I raised earlier that while I don't think these changes before us are necessarily going to result in any major impact in URB and URC, I am concerned that if there's a number of incremental zoning changes made to URB and URC over time, scale of 20 years, 30 years, that there might be a measurable loss of tree canopy and an increase in impervious surface in wards like Ward 3. So I hope you'll at least put mechanisms in place to measure by ward the amount of tree canopy and impervious surface by ward reported to the citizens once a year so that we can see what's going on. If the cumulative effect of zoning changes or other things are affecting these metrics, then we can take action. Thank you.
Anybody else?
I'm Paula Barron. I live on 72 Lily Street in Florence, and I, for one, am very excited about this. I have a garage, and my neighbors, actually, the same thing happened to me that happened to you, Jerry. I woke up one morning, and they were doing construction, and they completely blocked my view of the hills, and I was very upset about it. I called the town. They said, yes, they have a permit, and there wasn't anything I could do about it. They put an in-law apartment on, and it was completely fine because they had, they did an addition to their home. And my mother's elderly, and I would like to renovate my garage, and their in-law apartment is less than 15 feet from my garage, but I was told, I've been trying to do this for almost 2 years now, and I've been told, no, I absolutely cannot do that because you know, it's not attached to the house, and my garage is maybe 15 feet from my house, so it's very, very close. So when I called Carolyn, and she said that this proposal, you know, was on the table, and I'm very excited about it. I'm really hoping that it passes because I really would love to be able to do as my neighbor did. You know, it's an existing building. I wouldn't be going up, or I mean, it wouldn't block anybody's view of anything. It really would be very helpful, and especially in these economic times, you know, to have more space to put my mom in there. So I'm excited about it. I hope it passes.
Anybody else?
Dennis Helmus, 174 North Street. I just would want to echo what Alex Giesland said, is that since the Zoning Revisions Committee was just constituted, I would like to hear what they have to say about zoning proposals before adopting anything, even though I understand that the impact of this is probably not going to be significant on any grand scale, and would help somebody like you. They already ruined your view, so why can't I put my mom in the garage? I hear you, but that would be my request.
Anybody else?
Steve Hathaway, 32 North and Ave, Northampton. I guess mine's more of a question than anything, is I'm confused about what problem this legislation is being put out there to fix. I keep hearing that it's not going to have any significant impact, but if it doesn't have any significant impact, why are we doing it? How many cases are there that this really needs to be done to resolve? And it seems like special purpose legislation, sort of, because I'm just not seeing how it's causing such a huge problem for so many people. On the face of it, it doesn't look like it's a big problem. You basically have to have either own both parts or have agreement with the people that are right next to it, but I'm just not at all clear on how this got to be a big enough problem that somebody felt it needed legislation.
Let me start with the big picture, and then Carolyn, who deals with this day-to-day, might be able to talk about more specific ones. But just to go back where this came from in the first place, and I don't disagree at all with Alex said about URA needing to be looked at, but the reason URB and URC is where this started is in URB and URC, you're allowed to do 2-family homes, 3-family homes, and townhouses. And I had no problem whatsoever with multifamily homes. But what we heard from a lot of people is they didn't want zoning that forced people into multifamily homes. And if you had 130 feet of frontage prior to zero lot line development, you could do a 2-family home, you could do a 3-family home, you could do some number of townhouses, whatever the math is big. But if you want to do a single-family home, you could only do 1 home. So part of this was to try to sort of equalize it a little bit, and again, not to stop multifamily homes, but we were getting people who were forced into multifamily homes. So the example I often give is that the first one that really kicked us off was the Habitat for Humanity home on Pinebrook Curve, just above Big Y, where they were going to do 2 units, and what they really wanted was a 0 lot line home, 2 buildings against each other with a party wall, each on a separate piece of property. The zoning at the time didn't allow it, so they were forced to do a condo, and 2-unit condos are just messy, because what if you vote for different things? And so that's what started down the path, and so that's what made this appealing from our standpoint, is saying we think single-family homes work well, they're more often owner-occupied than other things, and so it's, and Carol will talk about the details of the problems. That's why we're somewhat advocates for 0 lot line.
Okay, thank you.
I mean, I talked about some of the details previously. No, it's not a huge number, but of people who are having issues and who are required to come to the planning board. But I think overall, as we look at the zoning, we're trying to eliminate, and we've heard a lot from neighbors and the city in general, about trying to make things less burdensome for the population as a whole. So even though many zoning changes that get proposed have sometimes have the effect of making things less onerous or burdensome to people, if it only affects, you know, a small number of people, each change that gets made cumulatively, one of the goals is to really not try to put impediments in front of people for trying to create infill or better development situation. So, you know, I think one of the bigger issues surrounding the changes is really to make it facilitate development for individuals and not require them to go through an onerous process.
Ready? Yeah, the table, the Northampton Code with the table, there is a 0 lot line allowed now for URA. Where does it say anything about just URB and C here?
Maybe looking at the cluster provision, I'm not sure, I'd have to look at that ordinance, but, let me see what you're looking at, I don't have it in front of me, sorry. So this is within a cluster, so if you're doing a cluster, you can also
Where
do,
does it say that?
this is a tabbed in, it's under the heading of cluster lots within a residential cluster. See the line immediately above it?
Oh, it's not immediately, okay.
So this is, so there are two places where you can create zero lot lines lots. One is as part of an overall cluster development where you need at least 4 acres to start with and you're doing, you're preserving 50% of the land in open space. And there are different ways you can divide up the remaining portion of that property into lots. And one of them is to create zero lot line single family lots. That provision is allowed within URA. So if you're doing a cluster, you could create, instead of townhouse lots or 2-family lots, you can create zero lot line lots. And that's the only way within URA or the other districts that you can have zero lot line.
Any other questions?
So where does it say what zoning and areas use applies to?
Well, in the table of use, so that same section under URB and URC, there is a line that says zero lot line single family homes. And it says allowed in URA. So table, in the attachment 1, under residential uses,
So,
it's a line in that table that goes across and you read.
You wanna tell us what table you're on, Franny, if you wanna, everybody look at it?
if you remember, Franny, I think a couple of weeks ago, I recommended that we have a little review of the tables, just because they do get kind of confusing, at least for me. Maybe what we want to add in the language, if and when it moves forward, is a reference to the table somehow, so that those of us who are not up to code, so to speak, can
Or at least a copy of what the table will look like in the proposed legislation. I mean, referring to a table we don't have is not really useful.
I was wondering if we could just review how we got going on this particular revision before the zoning revisions
Well-
group had stepped up on the other changes, just to respond to what.
Well, the zoning revisions committee is set up, they've only met once, and that committee was set up specifically to look at changes to zoning as applied, that were derived from the sustainability plan. So their charter is not to look at every rezoning or every zoning issue throughout the city. So, and they've only met once, and there's still a long time before that group starts coming up with their recommendations. So this actually was a continuation of something that came up before that board even existed. So that's why it hasn't gone, and not every zoning change is gonna go to the zoning revisions committee.
It's important, because I think,
Right. There will be some that the zoning revisions committee will bring to us on their own. There will be some that the planning board will recommend to the zoning revisions committee. But this matter started before that committee even existed.
although there are some components of it which are reflected in the sustainability plan, which have to do with infill.
So components of this
Yeah,
particular piece.
yeah.
Sure, but the zoning revisions committee didn't exist before this
Right.
even started. So.
How long do you think it may be before you hear anything back from the zoning revisions committee?
Well, the zoning revision committee has met once, they're meeting again April 1st, at which point we're gonna be doing training on zoning for those members. Some of the members are familiar with zoning issues, some are not. And then we're gonna be going over the appendices from the sustainability plan, which list all the possible zoning changes that are just outlined in that plan. If you've looked at that plan, I'm sure you have, you know there are dozens of possible zoning changes in that plan.
At least a year?
Oh, no, I don't think that long. I think one of the ideas we discussed at the first meeting is try to set a priority for some things that we think we can do quickly, some things that'll be long-term, and some things that may be medium-term. So we may actually be forming subcommittees of that group to look at some of the bigger picture issues while we start trying to knock off some of the smaller ones. Mike?
Just for a little bit of a background on that point, being one of the 4 people on the subcommittee that drafted the rezoning committee 2 of the other members of whom are in the planning board in the room right now. There was always a recognition that there would be other matters that would be considered and brought before the planning board and the council while we were forming this committee and get it up and running. And there was a recognition that things would not stop, that things would be going forward. So that was always part of the discussion. And then when it got up and running, whatever was coming its way that was related to the sustainability plan would go there, but not that we would hold everything back. And I think that was just an upfront recognition that it wasn't meant to delay everything.
Exactly, and I think, and that committee understands that as well. So they don't expect to see every piece of zoning that comes before us go to them.
Another question, unrelated, is there was a rescheduled workshop on this. What was the response like there? What was the attendance? What was the degree of questions? Was there a lot of opposition or support that we're hearing, or not hearing tonight? I'm just curious. I was unable to go to the rescheduled one, so I don't know.
As I said, I didn't take a head count, but my guess is somewhere around 20. Maybe Bob, you were there.
15.
15?
15
Okay.
tops. Many of whom are in this room tonight.
And there wasn't really a discussion about being in favor or in opposition. It was really a question and answer, and people really wanted to find out more about it.
It wasn't a public hearing.
Right.
No, but sometimes people give you their opinions anyways.
Yeah.
Some concerns.
Yeah.
Very
Yeah,
concerns.
yeah.
Well, the URA question was raised in that meeting. Why doesn't it apply to URA?
Absolutely, yeah.
So, in terms of what we're going to do with this, I've heard one possible wording change, which was for Article, or F3, which I guess is now B3, about changing both sides of the property to both sides of the zero lot line. I haven't heard so far any other possible changes. Randy had his point about whether or not we want to beef up the number of trees, but I'm not sure if you felt strongly enough that you want to change it.
What about neighbor notification, butter notification?
Well, Bob, was it?
Yeah, I mean, I'm torn. I certainly see this where we would give control of the decision about this issue to the most affected neighbor as a good a step in the right direction. I am trying to figure out if there's a structure by which the applicant could, through the Planning Office of Planning Development, notify abutters and abutter within 300 feet that this negotiation was taking place.
So you're talking
That's
about
not
the
what the
situation.
normal, that's not what the normal public notifications are about, so it may be hard to structure that kind of notification.
The one model we have that works moderately well is the demolition delay ordinance. The theory being, that's a little different because a year delay might actually force people to the table. But take the same concept. If you notified neighbors and said, you have to notify neighbors at least, making this up, 60 days or 90 days before you create the lot, if neighbors are talking to each other, which generally is true, but certainly not always true, at least the neighbors know about it and have a chance to do a dialogue. It doesn't give anyone a veto, but at least gives them the opportunity to advocate. It avoids them waking up one day and seeing the project without giving them a veto. So you could use that approach.
And do you think that's a difficult letter to craft?
No, I think that'd be easy to do.
Okay.
Whether it's desirable or not is up to you.
Well, but so that would be a way in which, because the fact is now for zero lot line lots, you don't have to do a public hearing. But if you want to add on the side of your house and encroach, then you do. And this is what, this language will let people do that without a public hearing. So that's why I think that this notification letter that somebody's creating a zero lot line lot with a brief description of what that means they'll be able to do might be helpful.
So, Wayne, do you have possible wording?
Yeah, I'm just going to, X days, you have to fill in 60 days or 90 days prior to creating zero lot line lot.
45.
45 days. The applicant shall notify all butters within 300 feet, provide documentation that's said to building inspector. I mean, I can tell you language.
And how about posting the posting mean, I think that's a pretty effective thing.
Yeah.
And presumably it would then be on the OPD website as well, if you want to see it. Is that right?
Well, now, one of the intents behind this ordinance, I think, was to try to streamline the process for the applicant. And now we're going down another road, I think.
Well, they're gonna have to have the drawings we're talking about anyway.
To apply for a building permit?
Yeah, yeah. So they have to have the drawings anyway. If you were doing an addition now, not only would you have to notify the same group of people at the same expense, but then you'd have to come here in front of you people and get you to agree after the neighbors comment. So it's a much more onerous process now because you've got to come to the public hearing and get a decision from the planning board.
If I don't want to build a fence, or if I want to.
That's not, if I want to build a side addition, this is not about zero lot line.
Okay.
So if I want to build an addition in my side setback, and I have to apply to the planning board for a special permit, that's when you notify 300 feet with all the, and they have the public hearing. So that's what I'm saying, is that in most cases, I would suspect that more than half of the permits that are pulled for this reason will be for an addition. And that's especially why I want to preserve the notification requirement. I want to lighten it, because there is no public hearing. There's just the notification that David's, I got to make a deal with him, you can talk to him. So you're just letting the neighborhood know what's going on, what my intentions are, and that's all. I don't care if it's on the OPD website or not, it's wrong.
No obligation then for the applicant to respond to the abutter 200 feet away or whatever.
Yeah, just that the abutter's about 200 feet, 300, whatever it is now. And just tell them what's happened.
George, just because we're trying to make it easier for the improver doesn't mean we can't reform the process too.
Well, I think the concern is it just as much work for the planning department?
Well, the way I'm drafting this is have no work for us whatsoever, so I like that part. So let me read what the language is right now. I can't read my own writing, so I can slow it. 45 days prior to obtaining a building permit for a zero lot line, the applicant shall post notice in the property and shall notify all butters within 300 feet of the project, notifying them of the proposed change, and shall provide documentation of said notice to the building commissioner prior to obtaining a building permit.
We want to have them give them a drawing. It has to be a plan. You can have all the words you want. If people can see a plan on paper, and here's your house, and here's my house, that'll be the most useful thing.
Did you put the poster in?
To these abutters.
Well, no,
I guess if I were a neighbor and I got a notification like that, I would make the assumption that I had some recourse. So the first people I'd probably call would be the planning board. The planning department. So, you may be getting a lot of phone calls.
Well, and then we made the
And telling them they have no recourse.
Yeah.
Yeah, that's gonna go.
you're basically getting a letter saying,
Well, saying that I'm going to negotiate with David is what the letter would say.
but there's no recourse.
Only that all of you, my neighbors, can get together with David and lean on him not to do something that's in your
Well, Jim?
cost.
I just, along the lines of what Marilyn says, notification without recourse feels a little like a setup. And then disappointment when people get this and think, usually when you get a butter notification, it means there's a public hearing, you can come and state your piece and argue your point. And here you're getting notification and then you call planning and you talk to your neighbor and you're told, well, there isn't anything that you can actually do, we just thought we wanted to let you know. It seems like maybe it's a little bit of a setup. That's just gonna make people angrier. I don't know, I mean, the flip side is
understand the point.
waking up and seeing the
Right.
thing starting
Right.
isn't pleasant either.
Right. You all
But-
want to have public hearing? I don't think so.
Yeah.
Yeah.
Quite a number of ones.
So we have a possible, well, this isn't even an amendment, this is now a change to the ordinance. or change to the proposal.
Yeah.
So, I guess if we're gonna, assuming we're gonna vote on this tonight, whoever makes the motion, do they have a chance to move with or without that change?
Yeah, you're making, I mean, what you're doing is recommending to city council whatever your recommendation is, and you're recommending whatever additions you want or subtractions you want.
And that's true. So this is a recommendation to the ordinance committee of the city council. This is not an approval of the zoning that we're doing tonight.
And so the planning board can make their own recommendation, as can the ordinance committee and then the city council in our wisdom.
Right, so the order is us, planning board, to the ordinance committee to city council, where the vote, the final vote will be taken. So maybe what we're gonna do is, or George, if you have a comment, I was gonna say, maybe we should get a motion.
Well, I think there's one more issue that I just need to vet a little bit more, and that's the one in the table where it is, this all does apply just to URB and URC. And I guess I'm not quite sure yet why not URA, because it's within walking distance of downtown, public transportation, possibilities for.
I don't disagree. Right now, it's not allowed in URA. I don't disagree at all. It would make sense to do it.
Yep.
The reason it's not there is because the logic originally was to equalize them with the multifamily homes. And because we don't allow multifamily homes in URA, we weren't there. You follow what I'm saying?
I follow that.
Part of the logic originally for zero lot line development is if you had 130 feet, you could do a two-family home by right. So why wouldn't we allow two single-family homes by right? In the URA, you can't do a two-family home by right. So zero lot line in URB and URC may be increasing density, but it may also be switching housing types from two families to single family. Zero lot line URA would definitely be increasing density. Now, that may be a perfectly good thing, I'm not arguing against that, but it came from a different direction, that's why it wasn't there. And again, maybe we should go there, as a practical matter, notice the paper didn't include URA. So you'd want it, if you were doing that route, you'd want to notice URA neighborhoods too.
So maybe a motion from the planning board at this point. That's where we need Keith. Where is he?
And now it's that.
Just the motion maker.
I'll make a motion.
Okay? You have to actually move to close the public hearing first.
That's the motion.
All right. You look like you want to read us the ordinance. I just want to make sure. Go ahead.
Make a motion to close public hearing.
Second.
Second, Jen, second. All in favor? Brandon, did you vote? Come on.
Okay, I'll make another motion. This is a motion to recommend to City Council approval of the zoning ordinance amendment to simplify zero lot line development, eliminate fences, reduce 30-foot side setbacks to 15 feet, and allow lots next to non-zero lot projects. With the changes that we discussed related to, could you read those back, Wayne?
Yeah, so this is on the new section B3, where it says agrees to design covenants that control the design of both sides of the property, say controls the design of both sides of the zero lot line development. And then, do you want the one about the 45 days?
Yeah.
Okay. So 45 days prior to obtaining a building permit for a zero lot line, the applicant shall post a notice to affect the property and shall notify all butters within 300 feet, providing a copy of said to Office of Plan Development, showing the proposed plans for the property, and shall provide documentation of said notice to the building commissioner prior to obtaining the building permit.
Oh, need a second first. Is there a second?
I'll second.
Catherine. Discussion, George?
Was there some language in there about referring to the tables?
I can if you want. I wasn't exactly sure what you were looking for. So I made a note. I wasn't sure that's editor's note or if that's really, are we just saying C table dimensional regulations?
That would be great,
Okay.
and are we able to specify where that's found, a specific table that's found in the?
We give a section number, I know what it is, a C table dimensional regulation. So this would be, that first paragraph says where the opposite side meets the standard side yard setback of the district. Just in parentheses to say C table dimensional changes section, whatever that is, I don't know.
that's helpful for me.
Is that a friendly amendment for your motion? Any discussion on the motion?
Yeah, I'm really intrigued by the whole idea of the URB and the URC and not the URA at this point. I think we've been down this road a couple of years ago around the Smith College Engineering Building when it came up, and you know, we didn't hear from the URA folks at all. And then all of a sudden, when the discussion went to the other side of the Smith College campus, they came out in force. So it just seems to me that we are pushing somewhat the infill into certain areas, to certain, not specific neighborhoods, but it's just not unilateral. I can understand why it's not up in, you know, Ward 6 and 7, because that's not where we want the infill, but I think there are areas in URA where infill is, would be the same as in URB and URC. So I would rather see us wait a while and include that within the tables and within, you know, the intent of this. So.
I agree, I'm uncomfortable with two things. One, that it's not consistent. That I understand the reasoning behind URA, but it seems like it should be applicable across the board. If we're trying to streamline things and make it easier for people to get through the process, then it should be easier to follow. And you'd say, why is it B and C and not A? For the same reason, I'm uncomfortable with the notification process, that if you have a nice project, if you're doing an apartment for your mother and everybody's in favor, no issues, it goes right through, don't have to involve the planning board, I get that, that makes a lot of sense. But if there's a project that doesn't make sense to somebody, and a butter who's not next door, but they might be behind or across the street, and they get the notification, but they can't do anything about it, that just doesn't make any sense to me. So it seems like there should be some mechanism, and maybe there isn't, but to pull the planning board out of it for things that make a lot of sense to everyone, but at least give somebody a voice. If we're going to notify them, then give them a chance to make their voice heard.
Can I go back to the URA issue? The notice draft to you. The URA is, you know, we talked about what needs to go before the zone regulation group versus what doesn't. URA is much more complex. I don't disagree at all. As you know, I like the ordinance that didn't pass to change a lot of URA basically in this side of the high school. And so I don't disagree at all. The problem with the URA, I think requires a more fundamental look at, is whereas URB and URC tell a story. URC is basically the donut of densest development around downtown, with some exceptions on Jackson Street. URB is the next donut around downtown and the first donut around Florence. So it's pretty clear it's mostly pre-World War II housing, etc. URA doesn't tell as much of a story. In downtown, the URA district don't make sense. You have an island of URA on a hillside. I have no idea why. You have an island of Ward Avenue, and I don't really have any idea why. Then you have the post-World War II subdivisions on the north side of Florence, but are surrounded on three sides by URB. Then you have a lot of Leeds Center, which is URA. Then you have our water supply district near Ryan Road Elementary School. And so they shouldn't all be treated the same. You know, up to the high school, I absolutely agree. It should be there. I'm not even sure that it should be URA. But I'm not sure it would make sense in those areas. I somewhat don't think it would make sense in the water supply district. And so I think that's a bigger, I'm trying to pawn this off in the rezoning committee, but I think it's a bigger issue that's not going to happen anytime soon.
Marilyn?
In addition to the concerns that I've heard shared from my colleagues on the planning board, I guess I have some sort of pretty global concerns. One is that I'm really uncomfortable with, while I can appreciate, you know, expediting things for the planning office, for sure, I'm not sure it expedites anything for people who want to do something. In addition, I'm really concerned about the public process. And not having as much public process around what potentially we're saying doesn't have much, or it may not have much effect, but potentially it could. If we make things easier, if you open up access, people think of all kinds of ways to do things that you never would expect. So I'm uncomfortable with that. I'm also concerned about the neighbor-to-neighbor relations. And I think if someone came knocking on my door and wanted me to, put a restriction on my house, I'd be just uncomfortable with it. And, while it may be a good idea, it would be a headache for me. And I might tend to be a neighbor that said, all right, and felt pressured. And the notification, I'm real uncomfortable with that because there's no recourse. And I'm uncomfortable with neighbors pressuring other people. So I'm pretty uncomfortable with it as it stands.
Nice. Again, I'm not trying to count noses here, but just so you know the options out here. I think a lot of people's concern is this one paragraph. This issue that changes it from if I own both properties to that I can work with my neighbor. So certainly one approach you have is to say, let's do the streamlining where you don't have to go to the planning board if you don't want to do the fence. You don't have to do the double setback on the other side because it's a little odd to require 30 feet when everybody else is 15 feet. But don't do, this may still come back at some point, but I think 80% of the opposition is that one sentence, and as an incrementalist, you could say, do the rest and come back to it. Now, the problem is it still doesn't solve the problem of all those findings that we get. This is potentially has a benefit of reducing all the findings back, but at least it does get you a lot of the way.
And then what does it do about the notification issue? Then there's still a hearing?
When notification becomes less important if you're not doing this. Because again, because the only, right now, no notification is required. So it may be less important if you're not suddenly opening up this whole new.
Right. Right, I can see D3 is the one where, that's the one where neighbors expanding. All the others are, by right now, you own both sides, you can do what you want. The only thing you have to come to us for is if you don't want the fence, or if you want the windows.
Yeah, we go from 30 feet to 15 feet, we expand it somewhat.
Right.
Although someone could always do a weirder shaped house. If you have 65 feet, you can make it work.
Bob?
I understand people's discomfort with the notification requirement, and it seems like it really doesn't go anywhere. So another way to skin this cat is to say, not for additions. That this is simply, this will be good for new family homes, for new homes, but not for additions. And that'll knock out, in my opinion, a huge chunk of the kinds of things that might go forward and lead to frustratingly elusive notification. Does that make sense? So we could say this is for new homes only, not for additions. Additions go by the standard route that it goes through now. If you want a special permit, come to you. All notifications happen as they do currently, and that takes out this notification, which is searching for action.
Well, I think that's the same thing. Isn't that the same as Wayne saying just remove paragraph B?
They're slightly different though.
Is it?
Yeah, because you might still have a lot 65 feet now, but you don't own any other property in your lot.
So if you just said it was only for new houses, then the notification requirement would come out, it seems to me, without much problem.
George?
So in the case of the public speaker from Lily Street, who has a grandfathered situation, I believe, that person would have to go in front of the ZBA to get a finding to put an addition onto the existing garage?
Depends on the situation. If the existing garage at the house meets the zoning, then they would not be eligible for finding. So it would depend on where, I don't know her house. If her garage was 5 feet off the property boundary and the garage was attached, she'd be eligible. The detached garage, she would not be eligible. So
this would not help it then.
This would not help her. No.
With the change, the current language, if the neighbor agreed, the language proposed, if the neighbor agreed, would help.
I guess my concern is at this point we have a motion and two rather large changes. Well, we have one friendly amendment we've accepted and two rather large changes to the proposal that I'm a little concerned at this point what we have that we're possibly considering voting on. I don't think we've accepted either.
Well, I can't make an amendment.
I know you can't. So, I'm trying to figure out, we have two more of these to go through too.
I was more just kind of justifying why I might not vote in favor of the motion. I wasn't asking for a change.
Okay. All right, so you weren't asking for a change?
No, no.
For the table dimensions?
No, not at this point, because then it would have to be re-advertised as Wayne said, so I'm just.
All right, well, at this point, I guess we have Ken's existing motion, which is to take the ordinance as written, including Wayne's addition of the notice of 45 days. So without an amendment to that motion, I would say we should vote on this. And the idea would be if the motion passes, that we're passing it on to the ordinance committee. If the motion fails, we either try again.
We still pass it on.
Well, we can pass it on without a recommendation. But the vote, Ken's
We can
motion.
recommend against it, they still consider it. Can't they?
Right, well, I'd say if we do vote this down, I'd say we take one more crack at it. Or do you want it?
To reword it.
Yeah, but we don't have to.
Seems like there's a lot of lack of support for this.
Well, then let's take the vote and then see what happens. So, all in favor of Ken's motion, which is to take the wording as is with Wayne's addition of the public notification. All in favor?
I'll vote for it, just to be consistent.
So I'm seeing one. All right, all opposed? All right, so the motion fails. So now, I guess.
Let's move to the other two.
Welcome to the chair.
Right, I know, it's like, so I think,
But would either dropping a paragraph here or Bob's approach of having this only apply to new single-family homes with that?
well, that's why I was floating that idea. It doesn't seem like,
I mean, I think dropping that paragraph 3 helps a lot, because if at the very least, we can prevent the person who owns two pieces of property next to each other, and they don't want a fence and they want to add a window, it seems silly to have them march through and ask not to have to put a fence in. So taking out that sentence accomplishes that. It's not what we want as a whole, but at least incrementally, like you said, it does a little bit. And then we could revisit the bigger picture at a later date.
well, remember, so all we're voting on today, all
It's
we're
a
voting on today
recommendation, right.
is to recommend to them. So they can take what we recommend, decimate it as they will. So if you want to make that motion, we do it, and I think we can do that one fairly quickly, or if you don't want to make, Jen?
Can I just ask a question of Carolyn or Wayne? I mean, I think that one of the public stated, I feel like we've decimated it to the point of it will help two people on a blue moon on a Wednesday.
No, I think, you avoid the number of people who have to come before you. I mean, if someone wants to drop their fence, as far as I know, you've always approved those. And so we're making people spend $200 and spend some time going forward.
Right.
So that certainly makes life easy. Likewise, the double in the setback doesn't really make sense, because everybody else in the entire district would be 15 feet. Why are these people 30 feet? So doing those two changes helps. I mean, we're still a universe of one person per year, but that's still nice to help that one person per year.
But you could also take out the requirement about the fence and the windows, or modify that.
What
What we're suggesting.
that's what we're suggesting.
So I'm saying, this is really the major.
No, but I mean, you could do that without all the other stuff.
Right.
You could do that to the existing zero lot.
I guess I'll say this. Let's have a motion. If there's no motion, let's continue on to the next one. I think the ordinance committee has heard our thoughts on this.
I move we continue to do that.
All right, I'd say we can, the motion fails, let's move on to the next one.
Can I just ask a question? Sure. So, does not a zoning change require a 2/3 approval of the planning board, or is this?
Only city council. 2/3 vote city council.
Okay. And then, so you guys it can fail here, and you guys can just keep taking cracks at it? Okay.
The only legal, the planning board's making recommendations. The only legal effect of the planning board voting against something is if the exact ordinance came up, it can't come back for 2 years. But the reality is it can come up in 2 weeks with an ordinance and some changes anyway. So it's a reality issue.
You know, if I might, I just see this as part of the public process, which is very often said there's not enough public process, but we just went through this whole vetting of it for the public, and it still just keeps going on.
Painted the truth.
Well, these,
All right, wait, number 2.
Can I just ask one other thing about, what's happening to the question of applying this to URA? Will that be part of the next iteration, or?
To me, URA is a bigger issue, and at least my line would be that should go before the revision. I don't disagree at all that URA needs to be addressed in a lot of areas, not
Sounds
just
like
this.
URA is a must, you know.
It also would need the advertising, because it wasn't advertised to include URA.
Right.
All right, so I'm going to open a hearing, a continuation of a hearing to amend site plan submission requirement to specify traffic mitigation payment in lieu of standards and required construction materials for sites to be comparable to those required in subdivisions.
Okay, so this is part of site plan approval. So this only affects any project that's over 2,000 square feet of a single family or two-family home. You can see a site plan approval from the planning board. There's some other thresholds in terms of number of parking spaces. So this is things that come before the planning board. There's a list of approval criteria that you look at, impact on the neighborhood, a whole host of them. We're looking only at 2 of those approval criteria. The first approval criteria is the B that's up here behind me. This is, you have to look at the convenience and safety of a project on transportation, basically, vehicular and pedestrian. So that's the basic setting that you're here. Site plan approval criteria isn't the same as going before a building inspector with a clear set of criteria. It's always a matter of weighing. You have 5 or 6 criteria, and you weigh things back and forth. So that's sort of background for this. So I'm just guessing time, but about 5 years ago, City Council asked the planning board, part of the planning board, to look at incremental traffic impacts. Planning board going back 21 or 22 years ago, when site plan approval was adopted, has always looked at big, lumpy projects. You know, a shopping mall going up is going to affect the street, traffic mitigation is required. But if you do a really small project, they didn't necessarily look at, you know, 1 new house or 5 new homes, looks at small incremental impact. So City Council directed the planning board to start addressing that 4 or 5 years ago. But there was no formula because we had no idea what the formula should be. And the planning board sort of been developing a formula over time. I think we all feel uncomfortable because someone comes and we sort of have a formula in our head, but it's not in writing, so the regulating public doesn't know what this is. So this is an attempt to address that language. On the version behind me in red, I think it's underlined in your version, is the new changes. And it's basically saying, you know, if you mitigate your traffic impacts, which is always our first choice, then this section doesn't really apply. So if you're doing a big shopping center, you're putting a new traffic signal on King Street, you're putting in new sidewalks, then you're all done. Bigger projects tend to do that. Smaller projects don't want to make the improvements, they just rather get you can. And so what this would say is, okay, for those projects, we expect you to pay a payment, you know, so the red language basically spells that out, it changes. It says, this whole paragraph here, it says, look, we still expect big projects like master plan projects, state hospital, plan village, to plan the entire project at once. We don't want to see this retail. Every time you get a log to state hospital, you don't want them to give you $20 or $2,000 for traffic impact. You want a master plan project. So the big new changes in here are having these specific tables. And the tables really serve, in essence, 3 purposes. One is having some agreement as to how much traffic projects generate. And it's basically what's called a rebuttable presumption. You know, it's how the board's going to assume how much traffic a project generates, but they may prove differently to you. So, you know, someone may say, yes, we have a project that by the table of use regulations generates 10,000 trips, but everybody walks here, nobody ever drives here. And so the planning board can take that into consideration. At least it starts the conversation in public, and so developers reading your ordinance know what to expect. So that's the first thing, the expectations, how much traffic it generates. The second is expectations as to what they're paying for fees. I'll go through all that in a second, but the third that's related is building incentives, openly and above board, for what's the stuff we're really trying to get. You know, we're saying we're trying to get people to develop within walking distance of urban areas, and we know that the national figures, people drive 35% less in that kind of project. So let's charge them less traffic mitigation. Likewise, we know we'd love to have more industrial uses, we'd love to have more office uses. And this recessional, I mean, we don't want to charge as much for those things. I think we can't really do that on the fly to the planning board saying, yours is a good project, yours is a bad project. But city council and setting policy certainly can do that. So that's what's here. This table, you know, the tables all changed somewhat from before, but okay, unfortunately, look at the version I passed out to you. Because the version up here is not the most recent one. So the version I passed out to you is the one you should be looking at for this. All right, I have a confession to make. My computer crashed, and I lost everything, so I have a paper copy that's not what you have. So let me just walk you through this one table, because it didn't rebuild this table when I lost my files.
You're saying what we have is not correct. What
The
you have-
table is not, right? I built the language when I rebuilt this, but I missed this table. So let me just walk you through. And the table you have, the table up here, is what the ordinance was originally introduced to City Council. This came before you in January. There was some discussion here, discussion before transportation and parking, discussion before EDLU, so the table changed somewhat. So let me read you what we have now. The idea of the table is the same. So the first category right now is central business, general industrial, special industrial, planned village except for medical and dental, and neighborhood business except for use of the gas pumps. Those will all be no mitigation. So it's what you have here. These are the places we say we want to have development, except not the state hospital for medical use, because medical use is very high traffic. Was never really part of the planned mitigation. You know, the idea for exempting state hospital is we've gotten a few $1 million of traffic mitigation already as a result of the project. So we don't need to double dip. But that traffic mitigation did not assume medical use at state hospital. Medical uses are really high traffic generators. And so if medical uses go up there, we do need more traffic mitigation, because that wasn't covered with what they've done already. The idea of neighborhood business is the reason it wasn't here originally was that neighborhood business, typically what we're getting, frankly, neighborhood business, is Cumberland Farms gas pumps, which are very high traffic generators. But if we really got the old-fashioned neighborhood business development, mom and pop grocery stores or tradesmen or those sort of things, that would be wonderful. That's walkable centers. So the idea is to separate this out and say there's neighborhood business that don't have gas pumps, we're not going to ask for traffic mitigation. That's what we say we want. We deal with traffic mitigation. The second one, $1,000, is unchanged. Medical URC and URB would be $1,000. The third one is changed a little bit. It's basically highway business district, and here, planned village for medical and dental uses. And then neighborhood businesses with gas pumps. And business park districts with non-exempt uses, which are basically uses that aren't otherwise, most business park uses that aren't already covered by master planning use. And then the others that are on this list are right. There's other districts within the same distance. And then the last category is the same thing as up here, except we then crossed out neighborhood business and business park because we've addressed them elsewhere, except for business park residential use. Business park right now allows commercial uses, which we say we want to encourage, and it basically is the same thing as suburban residential. So we should treat the residential side of it the same as suburban residential. Does that, you follow that?
No, you'll have to say that again, Wayne. The business park is what we envisioned down on Route 10 going through East Hampton.
So the residential part of the business park, basically, if you bought the land of the business park today, you would have two choices. You could develop it, in essence, as if it was suburban residential development, as of right. And so if you develop it that way, we're saying you should qualify to stay with an SR. Pay $3,000 per space for trip trailer.
The business park overlay, you can do all residential as a right?
So business park used to be suburban residential. Business park was done as an overlay over it. But the yes, you basically have the old rights that were there. And that's frankly the biggest concern is that in this market, the land's worth a lot more as SR than business park. you can only do a business park with big subsidies. And we don't want to exempt that back, because then we're going to get a suburban residential back here, which I like it proposed. All right, that makes sense?
When M is municipal, not medical, is that right?
And it shows up somewhere else.
Okay.
So this is by district, and
Okay.
we have uses elsewhere, so.
But the M district is municipal.
No, and this is medical, I'm sorry, it's Cooley
Okay.
Dickinson.
Okay.
Basically, it's only Cooley Dickinson.
Okay.
So, I am going back up top to the PV zoning districts, the planned village.
Yep.
It says no mitigation, yet we got mitigation from, the development at the state hospital. So why would we not want mitigation from a future planned village operation? Perhaps at the Leeds VA or the Leeds nursing home facility or something else?
I think because we have no other plans for PV anywhere else right now, I think you're absolutely right. If we remember that, if we ever do zone another place of town PV, absolutely need to get it. I think it's unlikely we do the Leeds long-term care facility because we wouldn't want that much commercial out there. VA, which 10 years ago I was certainly, saying was going to close at some point. With the Iraq War, there's no indication it's going to close anytime soon. But yes, if we ever did another PV, you're absolutely right. So we're not there right now.
There's no reason to put it in a table where it would cause us problems later. So can we just modify the table a little bit?
Well, the problem is you're required to treat a district as this uniformity requirement. You're required to have the same rules for the entire district. So if you're gonna exempt PV, you have to exempt PV. And what I mean is, you either want to change the rules if you zone an area of town PV, or you want to create a PV2, a different district. But you can't say one area is exempt and another area is not exempt.
Well, instead of saying no mitigation, we already have mitigation for the hospital property. So we would say no mitigation unless not provided by whatever.
I guess where else where would we put it if we had another planned village?
Well, the VA is right, but if the VA closed, that would be a logical place. To me, it's so far out.
No, where would you put it on the table? Where would you put PV on the table?
Oh, that's the problem.
You're not sure where it would go?
I'm not sure where we go. I'm not sure what the other way you do it.
But to say, if we have a planned village in the future, some 30 years down the road, we need to remember to come back and fix this chart.
Well, if you did a new planned village, I'd look at it. Doesn't matter, of course. If you did a new planned village, we'd look at, you do a word search to figure out where does PV show up anywhere in the table, and we come back to you and say, is that what you want to use in this district? So as a practical matter, you'd be doing that. Plus, 30 years from now, the zoning revisions committee will finally give their report. And you can change everything anyway. I think it's so far off. I mean, we're not doing. It's not like we're in the middle of doing any planning. We just finished a comprehensive plan, and the plan is not recommending any expansions of PV. So I think it's so far off that we're doing that. We really missing it.
Any other questions for Wayne?
Let me keep going. So this more section.
Oh, sorry.
Okay. So this is just this is the language. This came out of discussion before, but just to be clear, we're identifying what peak trip hours are. We're generally getting mitigation around peak trip hours. Again, this is the last sentence. Planning board has the ability to use alternative calculations of clear evidence that the contrary is provided. So, for example, Cooley Dickinson, if they have a shift change between 3:30 and 6, you'd want the traffic index. But if they were suddenly doing some of the shift change between 2 in the morning and 3 in the morning, you'd probably say, fine, no traffic impacts whatsoever, the capacity can take it. And that, we want to make the zoning as clear as possible, but those sort of weighing of issues, that's why you guys exist. You have to do that before you. So it gives you the flexibility to do this. Likewise, somebody has a little grocery store, it's half the grocery store. It's only part of the subdivision. Only people who live there can go there and walk. You always have the ability to look at other alternative things. And then, so this is the table, and this is basically, we right now spend $300 every 2 years to buy IT, these thick manuals of all the traffic generations in the country. And what happens, every developer in the country comes up to us and says, oh, I think I fit in this category of ITE. You know, yes, it says gas stations, but I'm really a different kind of gas station. So we just have a simplified table so we all agree. Again, it's rebuttable. There's nothing wrong with somebody saying, my convenience store is only going to grab people driving by my business. It's not a very good convenience store. No one will ever drive here. That's okay.
They'll be selling worse mousetraps.
So you guys will still have those discussions, but at least we're start on the same page. You know, people will start, we'll all agree what this stuff is. And that's the biggest thing. So everyone will say, it's all drive-by trips. It's trips that are on the road anyway. And then you can make that judgment, but at least we're getting rid of the arguing, you know, does a gas station generate 100 trips per 1,000 square feet or 140 trips per? You look at the IT manual, it sounds really cool. There's a book, you look it up, and then you read the sample size, and it's like 3. You know, 3 studies around the country. And Houston studies are not exactly the same as Northampton. So we're simplifying it, getting you the ability to look at these things. Somebody does, you know, Taco Bell says they're making so much money they're going to open another Taco Bell. They can lay down trip counters and tell you exactly what they have, and you can get other information. So at least we have the same points. And then you see again, this is the where we're encouraging stuff. Industrial manufacturing and tradesmen.
There's one missing.
There's one missing, which is municipal uses. We say exempt. And again, that's the idea of saying, oh, I'm sorry, there's a couple missing. So I apologize for this. Tradesmen's here are professional but not medical and dental offices and municipal uses. So again, medical and dental offices are very high traffic. They're really the highest traffic, among the highest traffic uses we have in town. And frankly, we don't need to do anything to encourage them because we have a hospital in town, we're getting them. So it's okay to have them pay the full freight. But if Citibank, maybe not Citibank anymore, who's ever left, wanted to move to Northampton and employ 500 people in credit card processing, we may well as a community say, that's great, don't pay any traffic mitigation, it's really important. And so having those things, and I apologize that I didn't catch this in the computer. Okay, that's the traffic piece. And the other piece, this is totally separate section. It's the same section of site plan approval, which is why it's the same ordinance, but this comes from a totally different background. This comes frankly from the Beaver Brook discussions. We have this 50-page book about the subdivision standards, the standards, but we don't have an equivalent in zoning. So this is saying, when you're putting a water pipe in a project, all that technical standards and subdivision regs apply. When you're putting a sewer line in, all that technical stuff applies. So we don't have to reinvent them. Again, it's a rebuttable presumption. We assume people are going to meet this design manual. You know, if you guys somehow think that plastic pipe is as good as concrete pipe, you can entertain that. You can ask DPW to give you advice. But the assumption is we expect people to meet what's this.
Wait, am I reading this right? It looks to me like in the 4th line from the bottom, it should say, shall be that set forth in the Northampton subdivision standards.
Yep. Thank you. That was an original error. That wasn't the computer.
So C is, we go within this zoning, within this ordinance change, it's 350.11.6, it goes B, site plan approval. B is all about traffic mitigation. C is something else, and D, we're adding D as a brand new D.
No, D was here already. We're really just adding the standards of that second sentence, the construction standards. Right.
On my copy.
Yours, that's on.
Oh, okay, okay.
Also, more questions?
I'm sorry, let's give you one more thing that I missed too. I really apologize for this. This came up, this is the language you saw in your public hearing. One person suggested instead of construction standards, doing construction materials and methods, which is somewhat different. Standards might mean, are sidewalks required or not? That's not the intent of this. The intent is saying, if you decide to require sidewalks, then you want the gravel underneath the sidewalk to be compressed to whatever the standards are the engineer is saying. Whether you do sidewalks is more of a policy decision.
Questions from the board? George?
The one large question I've had for a while, Wayne, is this all talks about mitigation in lieu of payment, a lot of it. if in fact they're not doing offsite improvements to the traffic. But nowhere in here does it say where that mitigation money goes and how it's used and what kind of planning there is around that.
So there's two answers. It could only be used legally for things that have a nexus to the project, some connection to the project. There's some flexibility. You know, a project in King Street has to do something along King Street. And there's two ways it happens right now. The planning board has the right, as a condition, to say specifically, here's how the funds can be used. So the new gas station being built on East Hampton Road, on East Hampton Road, paid $72,000, I think. And you said 50% of that to go to bike paths to help get people off the street, and 50% of that to go for traffic calming to mitigate the traffic that's there and slow it down. That's directly related to the business. We've accepted those funds. They can only be used for those purposes. We still have to go to city council to have them appropriated, but they can't be used for anything else. Some funds, you haven't set any standards. They can only be used for traffic mitigation, but then city council has more flexibility. So we got some dollars for the publisher company. And city council can appropriate them to DPW to do traffic calming on South Street or to fix the intersection in that area. So you can, part of your permit, spell that out if you want, if you identify it, or you could leave it later in the process.
So at the risk of overburdening the OPD staff, we don't have a kind of a ledger account of all the mitigation money and how it's been used or appropriated.
Oh, we do.
We do.
Yeah, because we wanted to get to this point, we may stop doing it now, but because we wanted to get to this point of documenting every project you've done, so we can show that we're really being fair, we're not doing this arbitrary breaches.
Right.
We've tracked every project, exactly what you did, what the standards are, and how it goes out. Now, unfortunately, I was also on my computer, so I have to recreate a portion of it.
At some point, that might be real interesting to us, and I would think the traffic commission, also traffic and transportation, to see how that's been used. And, okay.
Well, I'm hoping I emailed some, because none of my email was lost.
Any other questions for Wayne? Anyone from the public want to comment on this issue? Adam?
It seems to me, because URA is part of this, that you have some of the same issues that cropped up with the last ordinance about just referring to URA in blanket, but in fact URA is kind of heterogeneous. Maybe you want to fix URA, break it up, whatever you need to do to make it conform better to how you want infill to actually happen. Sort of related to that, if you can visualize, if you remember that the Notre Dame studio presentation, Envisioning Sustainable Northampton, they had a chart speculating if you add 10,000 people to Northampton, where development might occur in their interpretation of a new urbanist kind of way. And so I think it would be interesting to think about, is that chart, to the extent that you think it's a good idea for where growth should happen, if this traffic mitigation is going to be compatible with that. I guess I have some concerns that there might be a few areas, perhaps in Leeds or perhaps somewhere in the west of the city, where you actually, in a small area, wouldn't mind some more development, perhaps that mom and pop grocery store, but perhaps this either won't help it or might even inhibit the formation of that kind of new neighborhood center. So I'm not saying that necessarily would happen, but I think it might be nice to perform that analysis just to make sure it's not going to inhibit things that might actually be desirable.
So, we sort of did that, not for the Notre Dame group, but there's an equivalent map in Sustainable Northampton. And so that's sort of how these rings came to being. What you see, what makes it a little different is we have the districts, and then we talk about this connection to transit stops and sidewalks. So that, because obviously an area where you're connected to a bike path that comes into downtown or to Florence encourages people to bicycle and walk for doing it. So we didn't totally follow the zoning districts for this, because clearly if you're close to a bike path, you're less likely to drive those things. But that was sort of where this part came from.
Anyone else from the public? George?
I'll make a motion to close the public hearing.
Second. Motion to close public hearing, all in favor? Unanimous? You got a roll, George?
I'll make a motion to recommend the ordinance changes as described by staff and in our handout more or less. As, to move it forward with a recommendation from the planning board to the ordinance committee and the city council.
Second. Any discussion?
I just wanted, one thing I want to point out is that it still doesn't apply to A&R, approval not required lots.
That's correct.
You do not get any mitigation money from any of it.
Yeah, two things. One is it doesn't apply to any project that doesn't come before you. So A&R is projects by rights, only projects that hit site plan approval thresholds. The second language, to be clear, that's here, this is, other than cleaning up the language, this is the same thing you have right now. It doesn't apply to a project which could have come in as an A&R. Because, use the Turkey Hill Road project that we did, for example. We came before you as a cluster subdivision. But we could have done it as an A&R and actually had more lots as part of an A&R. You wouldn't want to discourage someone from coming for a cluster. So, remember, I do more recent. On the project we did on Ryan Road, just by the intersection of Sedestra, you could have taken A&Rs and divided that property up into about 6 lots. Right? We came into you for a cluster permit and asked for a total of 4 units. You didn't charge any traffic mitigation because I could have done 6 units by right and never come before you. I was only doing 4. You wouldn't want to discourage that sort of development. So things that don't come before you don't pay, and things that don't have to come before you but are sort of voluntarily coming before you.
All right, all in favor? Opposed? Unanimous? Yeah. Thank you, Chris. I'd like to open a new hearing on clarifying use standards for the planned village district. Wayne, I think this is you again.
Yeah. We don't think this is required, but the council for Colmorgan, in what maybe is an abundance of caution, thinks the zoning is unclear and wouldn't recommend that they got a mortgage, so it's a big deal. The issue right now is State Hospital is, what's allowed in the State Hospital is a planned village use, where you master plan the entire area with a special permit. And as part of a planned village use, you can do manufacturing, you can do research and development. And the zoning says that clearly. Elsewhere in the zoning it says, but you can't just do manufacturing. You can't apply to be a manufacturing project or a research and development project by itself. You couldn't have 4 factories in the top of the hill. It has to be part of a master plan development. Does that make sense? No. Okay. So, if I was, let's say nothing ever happened in State Hospital, it was a piece of raw land, and Colmorgan came in and said, I want to buy 20 acres, 50 acres, whatever it is, and I want to put a factory here. That use wouldn't be allowed. You don't allow manufacturing there. It has to be part of a master plan development where there's some commercial, some industrial, some residential. So the State Hospital, we say manufacturing is not allowed. Manufacturing as a component in a planned village is allowed. Their council is concerned that one could read the zoning and say manufacturing is allowed. So all that's proposed, this language in red, which said, everything in black that was there already. We say a planned village district is allowed to include these components. Residential unit, residential things, nursing homes, community care facilities, commercial uses, and included in that is research and development and manufacturing. So we say as a component of a planned village is all allowed. But then again, remember, another portion of zoning says manufacturing is not allowed. So the new language is just saying planned village consists of the following uses, which is we've had here for 10 years, which are expressly allowed as part of a special permit, even if they would otherwise be permitted in the district. So it's really just to clarify. Don't worry about the rest of the table, just read this table. I don't think it's necessary, because, for example, we don't allow zero lot line development in URA, but we do allow it with a cluster project. So we already have some of these things in the zoning, but they want to be clear, they're borrowing lots of money for the project.
You need to put an of after 85%, number one.
That one's been there for 10 years.
Okay?
Has Janet been asked her opinion? Is she concerned at all about this?
About the current thing?
Yeah.
She's not concerned, but she doesn't disagree that someone could be concerned. She understands their caution. She doesn't think it's bad.
It wouldn't change where manufacturing was.
That's correct.
That's the other way.
George?
The underlying district without the plain village does not allow manufacturing.
That's correct.
So should that sentence in red say that the last phrase be in the PV overlay zoning district? See, I get confused by this.
It's not an overlay.
It's not an overlay anymore.
Right. We changed that a couple of years, 3 or 4 years ago. Right. That's actually where his concern is. When I said, right, PV is the district. When I said we have this in lots of other places, he said that's exactly his concern, is that we have Planned Village as a district, and we have Planned Village as a use. And that's confusing, and that's the reason he drew this out from other places where we have, you know, 2 families allowed in a cluster, but not 2 families allowed otherwise.
Any other questions for Wayne? Any from the public want to comment on this? All right.
Move to close the public hearing.
Second.
All in favor of close the public hearing? You want to make a motion?
Okay, I move that the planning board recommend adoption of changes to the table of use regulation as outlined in the planned village district. What's the addition of the of after 85%?
Right.
Let's see, where's the, okay.
Yeah, read the third one, clarifying use.
Yeah, that's it. Clarifying, I just move we urge, or we recommend.
Second? Catherine? Any discussion? Wayne has the change to adding of. I think that was the only change. All in favor? Unanimous. Thank you.
Do you guys want to?
Thank you very much.
Do you guys want to?
Do you want to vote on the ordinances?
We'll get to that at our next ordinance meeting and let you proceed with your report.
Thank you.
Thank you for your hospitality.
Yeah, they missed the up.
Good seeing you.
Yes, hang on.
All right.
Just an announcement, if anybody's staying here for the state hospital, that is going to be extended, so we're just going to open it and extend it.
Oh, good.
So, sorry, excuse me, continue it, so you're free to go if you're going to stay out. That's why I was laughing, it was so slow. Jenny, you better leave it.
Hey Steve, when did you say that zoning workshop was gonna be?
April 1st, next Wednesday. It'll be very similar to what Wayne has been doing with us.
So never mind.
So it won't be budgeted.
I would have come.
All right. My gavel. I'd like to open a continuation of a hearing on the request of Tofino Associates, Northern Ave Homes for a special permit to construct 25-unit townhouse project with associated site plan, including driveway access from North and Northern Ave at 8 View Ave, Northampton map ID 25C-12 and 17. Actually, before you guys do your presentation, Doug, I'm just gonna have Carolyn give an update. So,
Sure.
you got 1 minute.
Get some setup to be.
So this has been continued twice. The first time, second time was the first time you all actually heard it. There were several, there's a long public hearing, as you remember, from January, and the applicant was asked, issues came up, and I think they were going to address some of those issues. What you have in, for tonight is not, you still have the same plans from the previous hearing, except the applicant submitted 2 plans, one that actually went to the Conservation Commission over the course of this continued period. One of the issues, one of the reasons you continued the hearing was so that Conservation Commission could dispense with their review, and then you would have that feedback. Conservation Commission closed the public hearing 2 weeks ago, and then there was a request by the applicant to withdraw the application, which you'll hear more about, I think, from the applicant. And this evening, the Conservation Commission approved that request for withdrawal.
Without prejudice?
I think without prejudice, but I'll have Doug describe that. But what's in front of you, just to clarify for the public as well, you never saw the application that went to the Conservation Commission. It had been modified from the plan that you all had seen as a formal submittal in that interim period of the continuation. So last week you received a copy of the actual layout that went to the Conservation Commission that was modified slightly, had 2 fewer units. And then another plan that the Conscom hasn't seen and that took into consideration some of the comments made at your public hearing in January. The applicant, even though the application was formally withdrawn from the Conservation Commission, the applicant wants to get feedback from the Planning Board about which plan to take back to the commission based on your assessment. So they're not looking for approval at this stage, and ultimately will be asking for what I think would be a continuation. So I just wanted to set that framework for you, and then you all received the staff report that included comments about some of the issues that have been raised by the public in the last meeting, and how some of those issues relate to your approval criteria and whether or not the approval criteria sort of speaks to some of those issues. So that's where we stand now.
Just as a note, I'm not sure, I know it's not in our purview, but for, I think Catherine and Marilyn and Mark, I'm not sure if they're aware of what the rules are in terms of building in the wetlands in this area. Is it something that you guys are all, that we should review, or, I mean, or is it
Well,
something?
there's no development there's nothing proposed in the wetland, but the Conservation Commission has full jurisdiction over anything that's within 100 feet of the wetlands. And there are 2 pieces of that review that the Conservation Commission undertakes. One is under state law, and the other is under Northampton's ordinance. And there are different provisions for development in the buffer. Under state law, it's not quite as stringent as Northampton in terms of development in the buffer zone and even in the wetlands. But the Conservation Commission would be the body that would determine whether or not there was an impact to the buffer and subsequently impact to the wetland, not the Planning Board. So you all would be looking at the other aspects of the development, not necessarily whether there was an impact to the wetlands, so.
So I guess the, you have the ability to discuss, the overall project and the relationship to the open space and the character of the lot. But on a technical matter, in terms of determining whether there is an impact and voting based on whether you think there's an impact to the wetland is out of your jurisdiction, because you're not reviewing the potential for impacts to the wetland. That's what the Conservation Commission has to do. right, I guess that was the point I wanted to make, because I'm not sure, you know, for Marilyn and Catherine and Mark, I don't think you've seen a project that's like this, where it's an issue, but. George, did you have a question?
Yeah, so we opened a public hearing back in January on an application. So what's the status of that public hearing, that application at this point?
For you, it's still open.
But we're not looking at that application or those plans.
They've submitted revisions, and the revisions, no, you're not looking at that plan because they've submitted revisions that went to the Conservation Commission that you haven't seen yet. And then another, again, layout, which applicants do for big projects, you often see revised plans. They haven't submitted all the supporting technical documentation relative to the revisions they've made, because at this point, they just want feedback, essentially, from the planning board, unless that interest has changed in the last few days since the talk of the applicant. But, so if they get a read from you all about which direction to go, or what other changes are necessary, then they would fully engineer the details necessary to address all the special permit criteria.
Now, would that be a new application?
No, it would be amended.
Okay, so who is actually eligible to vote on that? And does he want feedback from everybody or just the people who are eligible to vote?
Everybody here is eligible to vote, because you were all here for the original hearing.
Yeah, remember that was why we had the original hearing on that date, because all 7, or actually 8 of us were there that night.
So the hearing remains open?
Or 7.
Yes.
And so, again, we're not gonna, the applicant's not asking for a vote tonight. So, what we're looking at, the applicant's looking for is feedback on this modification to the original plan. If we're all set, we can have the applicant vote.
Is there a computer? The flash drive? No?
Yes, there is a computer.
What do you mean?
I meant to contact you about that, but since we were down.
Okay, so how would you like us to set this? There's
always a
two boards, and we have the
Once it gets going, so.
flash drive. I just didn't know how to sell it. So
Do you have a laptop or just the flash drive?
Just flash drive. This work, Lance?
Set it up over here by the crates.
Yeah, no, it's fine.
It'll be up there.
It'll be the same,
So,
the same
the
thing?
same thing.
Oh, okay. Yeah,
Everything's
that's
on.
right.
Do the best we can with what we've got. So Mike, why don't you put up the first thing I'd like is the 2 drive. They're active. Yeah.
Put that in motion.
It's on.
It's on?
So you stick your flash drive in there.
My flash drive? Pointer flash
Nice.
drive.
Whatever you really want.
That's fine.
Take a little while to load.
We're trying. And I'll move things forward and backwards. So I I go back? Good, great. That's a great start. Okay, so what do I do? Go forward back?
It's gotta wait till it reaches the drive.
I guess we should have warned it.
Takes a while.
Yeah, but once it gets going, it's fine.
You want to start, if you're showing the same thing, you want to start with, because we have the plans in front of us.
We certainly can. These two plans over here are both a copy of the entire site, as well as the majority of the site where most of the buildings are, blown up to a larger scale of the plan that we submitted in the interim to the Conservation Commission. The goal here was to create open space in the project. One of the things that we've gotten feedback on here was to try to find areas where people could actually play without going into the 35-foot buffer zone. You know, the comment was made that there was really nowhere to go other than into the wetland to get away from your backyard. And so we basically, this area here has been opened up to try to create some open space that is not attached to any yard, as well as another area down here that's been opened up. And this area over here is actually for snow storage, but there used to be buildings over here. The other advantage we got out of this plan is we were able to move things further out of the buffer zone. From a conservation point of view, we ended up with a total of 3 units that were between 35 and 50 feet from the buffer zone. We had more in the earlier plans, and moreover, what we also had was just a larger number of units that were either entirely or mostly out of the buffer zone. There's a sidewalk, just following this up, there's sidewalks that connect this end, go up to the other end of the project. Both ends have a sidewalk going out to the street, North Street.
Doug, excuse me 1 minute.
Sure.
Is this plan you're demonstrating revised concept D that we have?
You have it as revised concept, that is L.
Oh.
This is
L.
second plan that we'd like you to consider.
L1 and L2A. L2 and L2A, yes.
We're looking at L.
They're both they're the same drawing, except that this one includes, if you look up here, this is a 2 units along Northern Ave. So this shows the entire parcel, including the entire wetland area. That blue line is the wetland line.
Right. I think this is the one that's
Down here.
that one. Which one? This one. So L went in front of conservation, but D is what we're going to end up talking about.
We're going to probably talk about both because, frankly, I really am looking for, a sharing of views at this point on what direction to go, because it takes a lot of effort to put these things together. Even L is going to get modified for conservation if it's brought back. But if D goes back, then we'll bring that one to fruition.
Where's the loop road
The loop road in this one goes back here, comes around and goes out this way.
And that's gonna be different in the.
That's correct. That's correct. So just to be clear, there are a couple of the green areas. This is a detention basin, just that green line around the edge of the highest edge of the detention basin. Over here, this is a rain garden. And the edges of the street are shown in lavender purple, and the units are shown with orange lines between them. There are a total of 23 units on this plan, and there are 23 units on the other plan. So I think if you've got the old plans there, I'm still waiting for this to pop up. Is it ready?
Old
Can you
plans
get
from
me to the
January?
end of it? Yeah.
I don't think any of us have those. We've had
Well,
it.
let's take a quick look at it so you at least have a context. One more? What should he do, Carolyn?
Click on that, it
Click on the
should open
buildings,
your storage.
Up there.
Do you want to look, spread those out?
Just still
Does
taking
a
a little while.
does a rain garden look like a pond?
Go ahead, Mike.
No, rain garden primarily is it's a shallow area, and it takes,
Filled with water?
it will fill with water in a small rainstorm, and it's really for treating water quality. It's filled full of sand and grass. water from the driveway or pavement would go through there, it would clean that water, additional water would flow right straight through it or be picked up. So it's only really for cleaning the water would go through the grass, filter through the sand below it, and then be cleaned. It's primarily for cleaning
It's not
water.
just a stagnant puddle.
Absolutely not. There are specific requirements that it has to totally drain within a certain period of time.
So that it entirely infiltrates versus being drained to somewhere else.
Correct. And again, this is not like a detention basin, it's just for first flush, just for water quality treatment.
Still waiting.
If you want it, it's a slow computer, so if I
That's-
keep going.
That's fine. So basically, this plan was put in front of the Conservation Commission. The blue line is the wetland line again. There is a 35-foot line that you can see here. One of the things that they asked us to do was to move everything outside the 35-foot line. Hence, the buildings are further away than they were. I think it's worth looking at the other plan at this point, just. to see-
So one of the differences is you've moved further away from that line, is that correct?
That's correct. We've moved further away from the wetlands, and this plan that we've now got moves further away still in terms of a certain number of units, and those are the middle units. These units here that are at this angle in this first drawing, in this drawing, we basically put them further back from the wetlands and face them at a right angle
Oh, is this D?
together. This is
Now,
D.
yes.
Yeah.
And are they, are they smaller or are they closer to north?
They're further away from the wetlands. There are units in the group of them that are entirely out of the buffer zone, others that are, there's basically one unit where it's as close as where 4 used to be. The difference here really is that it's focused a lot less on cars and more on pedestrians. There are 2 roads in, but they don't loop together. So both the group of homes that will be up in this area will come in and out on the same road, and this one here will come in and out on the same drive.
Is that the paper road?
This one is the paper
So-called
one.
Paper Street.
Sorry, Carolyn, it's not, the drive's not showing up.
We're going to work with what we've got, I think. So again, in this drawing, we've got actually 2 rain gardens. We were able to expand that one a bit. We've added this one over here to treat the water in this area. And what's nice, actually, I think I'm going to pull these off. The best way to look at it is to see them next to each other like that, I think. Oh, tried. What's nice is you don't have this road going up through the middle, and therefore there is more green space in the middle here, more room just for people to move around. Frankly, there's less impervious surface on the site, so from a wetlands point of view, it's a better way to go. We have not shown the detention basins in any different size at this point because we haven't refigured the stormwater on this plan. So we presume that this detention basin will get smaller, which will mean there will be more open space as a result that's usable. And again, up in here, while in here there is an area of open space, up in here, there's a greater area of open space, longer area, and the same area down here.
What did you say was pink? Is that a
The pink are sidewalks or walkways.
Okay.
And what we did there is we actually have a retaining wall on both plans for a section of the project right in here. And what we're doing is running the path in this case, hoping conservation is okay with it, along the edge of where they allow you to impact. So you've got plantings that have been put in place on the side towards the wetlands. These are wildlife plantings that we're planning on putting in there as part of mitigation for the project. And then on the other side, there'll be a small rock wall,
And that's at,
2 to 3 or 4 feet max.
and that's at 35 feet of the wetland boundary.
Right, it's actually, the path is outside the 35-foot line, So 8 feet over would be the 35-foot line.
So you haven't done the stormwater engineering on this yet?
We have not done the stormwater engineering on this plan here.
You think your infiltration's gonna work that close to the wetlands?
Not sure you're referring to, go ahead.
Yeah, the other drawing that we did actually complete all the engineering for the first drawing. Actually submitted plans to DPW and got a stormwater permit for the project. It's been thoroughly reviewed by DPW and stated to be in compliance with both the city's requirements for stormwater as well as the DEP requirements for stormwater.
I don't think,
Plans that were approved by DPW, which plans?
Well,
this one,
that was.
The L tonight, not the.
the L, not the D. Yeah. We didn't see any major red flags in terms of getting the D to meet the standards. It's probably going to be easier. And if the location of that walkway becomes problematic, we would presumably move it further back from the 35-foot line. The idea there was to maximize the amount of open space we had that would be contiguous without a sidewalk going through it. So we moved the sidewalk down towards the buffer zone. I mean, there are other ways to run a sidewalk that would connect the project through there. That just struck us as a relatively attractive way to do it. It also has the advantage of connecting people very easily from this area out to where people now go out to the bike path over here. So everything basically feeds towards the bike path. And if people want to be able to walk out to North Street and into town, they have that option as well.
Has there been any more information whether or not you're going to connect it right there?
No, there really isn't. It's a hard road to get them to actually let you tie on the bike path. I'm sure that, as Wayne put it to me today, he's been doing nothing but bike paths lately. And I'm sure at some point this will, reach his radar, but it's going to take a push.
But that would take you right out to the end of North Street. I mean,
Northern Ave.
Northern Ave.
Right.
Which you can get onto the bike path.
Right now, the way onto the bike path is actually across this property. There is
Near
a
a railroad
path,
abutment.
an informal path. It gets steep right before the bike path. People walk their bikes up typically, get to the top and get on the bike path. It's easy because there's no wetland there to cross.
Mm-hmm.
At the end of Northern Ave, there's a wetland. So that makes it very difficult.
So I like the idea that you remove that road to some degree, gave us more impervious surface, but in essence it created also two dead ends, right? Two cul-de-sacs.
That's correct.
So
And
people
that's-
have to come in and go out in the same way.
Right.
You've also reduced some of the garages within some of the units and forced the people to park in these larger areas and then walk to their homes, I guess.
That was this area down here. In
Yeah.
both plans, we basically have fewer garages than we did in the first plan. Unfortunately, that doesn't really decrease your impervious area, but it does make for a different kind of lifestyle in those units where they're walking to them. And it was a discussion with the realtors that was interesting.
How many fewer garages?
I'd have to look at the original plans. Right now, I believe there are, I don't want to misspeak, but I think there are 9 or 10 in total. 1, 2, 3, 4, 5, 6, 7, 8, 8. 5, 6, 7, 8, yep.
Yeah, just as an aside, as I was thinking of this project, I was thinking of the co-housing projects, which basically do the same thing. There's a major parking lot, and then you walk to your unit, and I'm sure it's not easy all the time, especially during the winter, but it does create a different kind of atmosphere.
One good thing here is it's relatively flat.
Right.
Well, I guess that's, for parking, I think of, like, the place up near George Wheeler, the development there where there's not enough parking on site, and everybody parks on, is it Grove Street?
On Evergreen.
Evergreen. What happens is there's an overflow, and because everybody ends up parking on the street, it's hard to plow, it's hard to walk. I haven't counted the parking spots. I mean, are you accounting for overflow or for extra
There are,
parking for visitors?
I believe, 2 extra parking spots at this point, beyond the requirement for 2 per unit. We
And the
certainly
overflow is
could,
to go out to work.
one presumes that if there were overflow, they might, but frankly, what people tend to do is they tend to park up on the side of the street. Real world, they'll try to stay closer.
We're hoping that these units, because of the walkability attract, we could condition it to just one car per unit. But I think the developer might not find that too attractive.
Right, but
I find that
the spillover-
unenforceable, but-
Because of the spillover onto North Street, that's the one thing that, you know, if you got, because there's parking on the other side near the building in Seluzniak, and there'd be parking on this side for this development, so you'd end up with parking on both sides would be the lane down the middle.
Do you want to go to this now?
Oh, we've got it on?
Well, it's on.
It's on. I think there are a couple of things on there that are worth, well, maybe we can turn the lights off, down? Because there are a couple of things on here that are worth seeing if we can get them up there. And those are the density ones. I mean, these you've seen them reasonably well. Basically what this is a picture from quite a ways back of the area. And our buildings, the new buildings, this is Plan L actually, not that there's much difference at this scale, but that's where our buildings are. One up there, 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 and there. Trying to give a sense of the impervious area of the neighborhood, since density has been a discussion topic. We are going to bring, once we've decided on one of these, we will bring you an analysis of the density in nearby neighborhoods that shows both neighborhoods closer towards town, further away from town in this vicinity, and their overall density relative to this project. So that's closer in. The areas that are the least dense are in fact the things that abut this project. Northern Ave has some double depth lots here. Some of these houses own double backyards. If you looked at the other side of Northern Ave, you'd see that they all live with very shallow backyards. And those houses are quite nice as well. You're going on to the other plan here. And then you can see it here where you've got Northern Ave houses on this side with relatively shallow backyards. But just looking at the overall impervious cover of the area, I don't think you'll find that this project is out of keeping with the amount of impervious area in the URB district. And again, when we're doing our analysis here, we exclude the wetlands. We do not include the wetlands in the area where we take our calculations from. Of course, we don't know how many wetlands are on neighboring areas either, that we're just stuck with that. So again,
When you do your calculations for per square feet of open space per unit, or what calculations?
The calculations we do is units per acre, how many square feet per unit.
Okay.
We go to the assessor's tax rolls, we see how many units are in any given parcel, dwelling units, and then we basically calculate out the area off of that. It's not possible to get we haven't found a way to do an impervious versus pervious calculation, because we don't have enough information to work from. So this is, the last image is the original plan, just for a retrospective look. These units were closer to the wetlands in here. The side of this one was just barely 35 feet off. These lined up fairly close to the wetlands over here, which is why now we've got them running this way. So by pulling this building, sending it that way, by pulling this building, moving it that way, and basically adding a couple of units over here right down there and sliding this one over, we were able overall to move as many units as possible anyway out of the either out of the 50-foot line or even out of the buffer zone in some cases. So I think the biggest issue is, yes, there's a pedestrian connectivity that I like in Plan D, and there's a loop road that isn't there. And if the loop road is what governs your thinking, then I'm going to go with a plan that involves a loop road. But if it's not that essential to your thinking, then I would personally, my personal preference was to go with something that had less road, more open space, I feel better pedestrian connections and more aesthetically pleasing connections.
Well, I guess it's time for questions from us, or feedback.
Well, I for one would prefer D over L, just for the reasons stated. I mean, it's more pedestrian friendly, gets rid of that loop. And the staff comments, I agree with most everything you said in the staff comments, so up to 2.
And I was thinking, George, your point about the loop road. I like putting dead end streets like this. It's kind of it doesn't create any flow of walking. So if you're coming in, you are walking through. That's something I would prefer to see more of a connection. But in this case, with the loss of that impervious surface, I think the same thing. It makes more sense not to have it. I'm not sure if you felt strongly about it. You asked the question.
Well, if I could say, I also don't think you're losing pedestrian or bicycle connection. I think from a living point of view, it kind of functions better as a community, even if they are coming in from two different ends. For example, the units over here and the units over here, they come in 2 different streets, you might say, but they face the same area where people will, see each other, meet each other. If there are kids, they'll play.
Yeah, I don't think that necessarily we need the car loop through. I guess the question is whether you need to drive car. It's not the question of needing to drive a car from one side of the unit to the other. It's whether you need to have a loop that goes through. Whether it would be better for emergency vehicles, for instance, if they go to the wrong side by mistake or something like that. I mean, that's the misgivings about Plan B, is that there is no loop.
Yeah, can the fire trucks turn around?
Can you put up D on that just right?
They cannot literally turn around in there, and nor could they turn around other than by following the loop road in and out on the first one. In other words, if they went down to this parking lot, they can turn around in the parking lot if nobody's there, but the odds are there are going to be cars there. And they're not going to be able to turn around. They're going to be backing out of there. And the same is true for the other road as well.
And they've looked at this?
The discussion has been entertained with them, yes.
And?
It was a pretty preliminary and informal read, so I wouldn't want to characterize their response. I wouldn't have come if I didn't think they were likely to be okay with it.
This is still pretty much the illustrative design of what the groups would look like?
Yes, that would be 1 unit more than any of these buildings would be, but yes.
So this would, as you were saying, which is a great concept, they would face into each other with that open space in the middle. Some of them, the garages may not be here as illustrated, but...
That's correct. One thing all of these end units are smaller units. The roof line changes direction. There have no garages. They're smaller units. The units in the middle tend to be the ones with the garages. They're larger units. And that drawing shows 2 types of units, but it doesn't represent any one of these particular buildings.
What are the square footage of the smaller units?
The smaller units are around 1,200 and some square feet. Yeah, they get pretty small. We've got a 28-foot version and a 30-foot version. They're 22 by 30.
That's like a bungalow.
It's not a big house, no.
2-story.
The other ones are 22 by 36, some are 22 by 38. Those get bigger.
And they're all 2-story?
But they also include the garage.
Or 3-story or not? They're all 2-story?
They have a potential finishable 3rd floor, but you're in the roof.
Right.
So it's
A lot.
it's a nice sector. I live in a space like that. I like it a lot, but some people don't care for them. You're in the roof. So I really would love to, again, you know, if fire is a concern I'm hearing so far, other things?
Snow storage down here on this
Mhm.
lower parking lot
Yep.
that you've developed.
Right there, we were planning on doing snow storage, and over there for this road.
But what about down, all the way down to the bottom, that parking lot, the larger parking lot?
There's no question that there is gonna be snow, either snow movement with a machine, with a loader, or snow removal as part of this project, and we would give you covenants that would include such a mandate for the homeowners association.
Lots 20 and 21, if I went out there, they kind of sit up on a high point, right? And everything else drops down around there?
That's the area where it drops off this edge, right around there. If you look at the topo lines, the wetlands drop off fairly steeply in this section, and then it's more gradual as you go down from there. So yes, 20 and 21 are on a flat area, but then behind the area, let's see if I can see it on the plan.
What are you looking for?
The topo on the,
Yeah, that, to me, it looked like
yeah, I
it
can
was
see it, it's hard to see. It's actually flat until you get to about the 15 foot, I was gonna say 15, but. So beyond the area that they're allowed to have their yard, it's still flat. There is an old pile of dirt there, which looks like the pile is mounded up.
Right, it looks like a lot of old rubble there.
Yes.
Construction rubble and cement.
Yep.
pieces
But that slope really starts to drop off at about the 10-foot line to the wetland. And then the wetlands pretty much come right up to the bottom of the slope.
So there's, within the road system and the parking spaces, there's not a separated pedestrian and car pattern there. It's just a roadway. Your pedestrian walkway is on the outside, correct?
That's correct, as opposed to in front of the units.
Yeah, or any
Yeah.
kind of striping or separation. We're assuming that if in fact this happened, that the traffic would be so slow that there wouldn't be any conflict with pedestrians walking.
Yeah. Although very happy to do striping, you know, to indicate pedestrians closer to the houses as well.
That might show it in front of the units, the parking spaces in front of units 1, 2, 3 are pulled back further away from the road to allow a pedestrian strip to occur, like in front or in back of a parked car. So this parking is actually deeper than these.
All right, I'm sorry. In terms of the sidewalk, I think what Mike is saying is that this sidewalk here, these driveway areas right here are made longer so that there is room for a sidewalk, pedestrian access straight across those openings without interfering with the ability to park a car there. That's different, for example, than this condition up here, where we don't have that extra. You can almost see it. These are longer spaces. Those are 23 feet, 22 feet? I don't know. 24 feet, and those are 18.
So that upper access road, the paper street, does not have a sidewalk along either side or access from North Avenue.
It has a sidewalk on the other side of the street,
does,
right up there.
okay.
Again, the pink lines are the sidewalks.
And what's the other color? That color? Okay.
There, it looks better on my table than it does here. There's orange on the units, and there is a purplish color around the edges of the roads.
Okay.
What about trash or when you have dumpsters?
No, the assumption was that we would bring in, there'd be one contractor for the entire set, and that people would put stuff in front of their units on trash day.
Oh,
So there would be no central spot.
Okay, so the people who are living in, say, 14 are going to be wheeling.
they're gonna be I know frankly, our hope was the pedal people would do it. They would be able to put it out right in their front yard and,
Where do they keep it?
that'd be it.
Yeah, the people
When
that
it's
garage.
not
During the week, yeah.
outside, inside rather. During the week, you mean?
Yeah.
Can't give you a good answer on that. There's no plan for a shed outside to put all the trash in.
So the
We
people
certainly
without
could
garages,
do that. I
that's-
wasn't the, garages is no question, but if you're asking about the other
Right.
folks, it's probably a good question that I hadn't thought of. Good question.
Does it, the upper access road, driveway, whatever you wanna call it, does it have a name?
No, it doesn't.
And the other one would be called View Avenue?
The other one we would call View Avenue. It's always been called View Avenue. So they would have two different names,
Yeah, they would have to have it.
absolutely, from a fire point of view.
So that would, yeah. So the address is, this would be something off of View Avenue?
Yes.
All the units up to 14 would be something off of View Avenue, this would
Right,
be whatever street.
right. And I presume my unit numbers are not necessarily what the fire department would tell me to do.
Yeah, of course, we're interested in what the fire department has to say, but other emergency vehicles would be important that they not get confused also,
Yeah.
like ambulances and stuff.
I mean, clearly there are going to be different streets with different numbers to the different streets.
If there's a loop, if there is a loop road, what's the name of that street?
Then I think you have a different situation. Then I simply think you have a condo development with a sign at the entrance, and you've gone into you're really looking at it in a different way.
I'm good. You have strong feelings on any of the others?
Well,
Before I answer that, are we gonna take public comment now?
Well, I was gonna say, I think, before we discuss, I mean, we can discuss among ourselves, but I think this might be a place to take public comment, unless anybody has any particular questions left. Is anybody in the public like to talk about this?
Well, I would just say, first of all, this is the first time that anybody who lives in the neighborhood has had a chance to see this, so I would think that...
Oh, I'm sorry, you got a name of it.
Oh, sorry, Dennis Helmus, 174 North Street. So I think that we would need some time to think about it, just like you would need some time to think about it. Secondly, I would say, I had asked you at the last meeting that this so-called paper street, as you know, where the land court is currently is a driveway, which the plaintiffs contend are owned by the two owners here. The land court case is going forward, so there is no street. I know that Mr. Cole claims of right-of-way, but that shall be seen. You were going to check with the city solicitor to see, when I had asked you, since this whole thing could change, depending on what happened at the land court, whether or not you should continue to deliberate or not. So I guess my question would be, have you got an answer to
Well, we're not voting, so we're not gonna be deciding tonight. This is, I think as you said at the beginning, this is the applicant going back with feedback from us, so.
Right. Well, I'm just asking only because at the last meeting you said you were going to check, so I'm asking to see, did you check and did you get an answer?
I think it would be safe to assume that if we were to approve the plan using that road, and the road was disallowed, then the plan would not be able to
Right,
move
well,
forward.
the so-called road.
Pardon?
The so-called road. Okay.
Yes, Tom McCurry, 193 North Street. I want to make 2 points. First of all, I realize that you're not ruling, you don't have to consider the impact on the wetlands. That's not your area. It's easy to draw a line around the wetlands, so to speak, but understand that the entire area is wet. Relatively flat terrain, poor drainage. You can go out in someone's backyard with a post hole digger and strike water. Most likely, I wouldn't be surprised. I've done it in my own backyard, which is across the street. Maybe it was a wet time of year, I don't know. But I think we need to consider not just stormwater runoff, but also groundwater. When you put these structures on wet, spongy terrain, the water, you're displacing water. Water has to go somewhere. And where does it go? It goes into people's basements. That's just a hypothetical situation, but there are people around that area who do have water in their basements during wet periods. And I think it's relevant for you people to consider that. The other point I want to make is to reiterate what I had said before at another meeting. I passed out some information regarding the traffic situation on North Street, especially where North Street and Market come together, and the traffic comes in from Market Street, from North Street, and they try to contend for access to King Street under the railroad track. So you need to consider that. This plan addresses neither of those concerns that we've been raising all along. So you've been presented with two choices. Well, you have a third choice, which is neither. But you should be discussing those topics. Earlier we were talking about the impact of traffic pertaining to developments of this sort, so keep it in mind. Thank you.
Alan Seawald, of an attorney, and I represent the North Street neighborhood. Tom's comment is apt. This is a special permit hearing, and you don't have an obligation to approve it. This is in your discretion. This D stands for dense, too dense, way too dense. We're talking about where you're going to put the snow. Why are we talking about where we're going to put the snow? Because there's too many units. Why are we talking about where we're going to put dumpsters or garbage? Too many units. If you have a 1,200 square foot unit, you're going to keep your garbage in your house, in your 1,200 square foot unit for a week? I mean, this is an ill-conceived plan. When we were here last time, at least Mr. Kohout was talking about reducing the density. Well, I give Mr. Cole credit for reducing some of the impervious surface here, but he hasn't reduced the density. And all of the problems on this site, all the problems that the Conservation Commission was talking about, and the reason the Conservation Commission was denying this plan before Mr. Cole withdrew it, was because of its density. Too dense. It needs to be cut back significantly. And Mr. Cole is cutting back on everything except the number of units. He's cutting back on the places where people can store things. Let's talk about a unit with no basement, no garage. Where do you put your stuff? Where do you put stuff? I mean, this is way too much, doing too much with too little. And this is the board that has the authority to tell Mr. Cole, as earnest as he is, and this is not a personal disparagement of Mr. Cole. I respect him, but this is too much with too little. And this is the board that needs to tell him that. So if Mr. Cole is looking for feedback, that's the feedback that he needs to hear tonight. He needs to hear that this is not a project that looks like the neighborhood. Whether the density is similar to the neighborhood or not, it's not what the neighborhood looks like. This neighborhood looks like freestanding structures, many of them are duplexes, with foliage in between, yards outside, places for people to be. This is an ill-conceived plan, and I urge you to tell Mr. Cole to take it back. Take it down, cut it back.
Adam Cohen, 134 North Street. At the January Planning Board hearing, the issue of filled wetlands and are any of these structures going to be on filled wetlands came up. I think you said you would drill more test pits to try and ascertain that, so I'm curious if there is data from that. I sure hope that the board, identifies that issue before anything gets built, because as the 2004 hazard mitigation plan says, you run a lot of risk when you put property on a filled wetland, shifting foundations, flooding, that sort of thing. To reiterate about the density, there were some objections at the January meeting to the density, and this one's only 2 units less. So I really don't think that concern has been very well addressed with these new plans. At the Conservation Commission hearings, which we video recorded all of them, transcribed some of it, I hope you'll look at that. It's on the North Street website. And Paul Wetzel expressed special concern about these units here because of the water table. Some of the test bits say that seasonal high groundwater is 14, 16 inches below the surface. And an additional issue, which I don't think has been adequately addressed, is this area is full of large mature trees, which both absorb water from the roots and they intercept rainfall at their crowns. There are scientific studies that say when you remove a stand of trees from a transitional area like that, you may see groundwater rising by as much as 8 inches. I haven't scientifically proven that that will happen on this property, but I hope someone with expertise will examine that issue because I think there's just very little margin of error down here. I think generally the water flows into this area, and it certainly bothered Paul Wetzel a lot. I think with this plan, creating these two cul-de-sacs, you have this large area here where it's really disconnected from the existing street work, the rest of the existing street network of the rest of the neighborhood. So I think it's very much not like Northern Avenue, which I think is a very successful cul-de-sac. So my concern would be that these units and these units will be disconnected from the neighborhood, and that is explicitly disfavored in the Sustainable Northampton plan. Cole Construction claims that the density in this area is not materially different from other areas in this general area. If that's true, then I would ask, why can't we have detached homes, perhaps some duplexes, where there's variety between the homes, so it does, in effect, match the aesthetic of the surrounding neighborhood, if in fact the density is not materially higher than what you might find on some of the surrounding streets. A separate issue is, I think, this density does appear to be significantly higher than the lots within 300 feet. And so with a different issue, dimensional averaging, we talked about this 300-foot standard was used for what would be harmonious with surrounding lots. This is not harmonious with the surrounding lots within 300 feet of this area. You should be aware in Conservation Commission they were opposed to using salt for de-icing on this property because of the proximity to the wetland. Now you have the additional issue that a lot of people, such as these units, will be compelled to walk from their cars to these homes. That suggests to me a setup for a dangerous, icy condition every winter. I think it's going to be hard to control this without using salt, or perhaps maybe you'd be forced to use very expensive alternatives, which I would be concerned that over time the condo association simply will not do because of the expense. And then I have a specific concern about this area here. This parking lot is right on these lot lines, the abutters. Currently this is a lovely stand of mature trees, so this is going to seriously hurt these abutters' views, where once they had lovely trees and now they're going to have, with no room for screening that I can see, a not pretty parking lot. Those are some of my issues. Thanks.
Anyone else from the audience?
My name's Lawrence Tatro, 188 Bridge Street. My wife and I own some property on North Street, 154, which are on one of the corners of View Avenue. The house is situated where these lower buildings are in this retention basin, which a hydrologist has told the Conservation Commission. I know you're not making Conservation Commission decisions or thinking it, but the water table is right there. I have water in that cellar. We have water in that cellar now. And I was talking to Mrs. Fenton Thursday. She's got water trickling in her cellar. She's at 166 North, which is on the other side of View Avenue. I don't know about the little house after us. The man did come to the first meeting. His wife has had a heart attack and died, and he hasn't attended another one. But there's another house after theirs. And I can recall many times during the winter being in the neighborhood where the hatchways are open and everything, trying to dry things out. They said, even though the people that, the hydrologist that in the Conservation Commission was talking about, that the water table down that end seems to be the highest, at the highest point. And any removal of the trees and or putting a platform on with a house on and everything to press it, and then water congregating in that either detention pond or you call it a filtration pond, whatever, and less places to run off with an impervious surface and whatever, we are going to have more problems. I know that. And I'm not trying to present this as what I call it a NIMBY thing. It is problems. And I won't go into other things here. You've heard other things before. I don't want to tire out your ears. I'm sure it's getting late. But one thing, I would like to make one comment on what Mr. Cole said. With the parking situation, maybe a general parking lot, maybe with 2 extra spaces, and the run-up would probably go on View Avenue or North Street, rather than on some in Northern. Which the neighbor here just mentioned about the connector between North and Market and going under King. Actually, the property of the city, or the city street on North Street, along the cemetery, over to Twin Cleaners, which is in front of Northern Ave, we already have overflow with the business or in the Twin Cleaner business. And then when we have the funeral home, which is on the corner of Orchard Street, on the other side of North Street, all the cars are on View Avenue, or that when they overfill the parking lot, especially when they have a double viewing. You got 2 viewing, you got cars parked all the way down to Parsons Street on North Street, on our North Streets, all the way up to where this Twin Cleaners used to be. So we can't afford to have any more overflow if people that don't have enough parking on Mr. Cole's project, or people that are visiting everything, that, oh, we'll park out on North Street or View Avenue. We already got a pretty tight spot there. Thank you very much.
Anybody else? Doug, you wanna-
I'm happy to address things if the board wishes for me to address a specific item that's been discussed.
Well, if you'd like to respond to anything.
Okay. First of all, again, I'm going back to the aerial photograph. The density's there. That's what this, that's what this part of town feels like, and it's not a bad place to live. I live on a 6,000 square foot lot. I kind of wish I had 7 or 8, but it's a dense environment, but it's a nice environment. And my goal here is not to create something that's not a nice environment. You've done townhouses that have had a whole lot less open space than this one does, a whole lot less diversity of housing type than this one does. I think this project has some real potential to be an interesting project, and I think I'm here really talking to you. The garbage, yeah. There are things here I need to think about, things I need to polish up. It's not a finished product, but I think it's really got the chance to be a nice place, and I think the people in the neighborhood won't be isolated from the neighborhood. Bringing 2 streets out into the neighborhood makes it that much more of a part of the neighborhood. The fact that people use the trail, the sidewalk that's on the, I'm going to call that the east edge of the parcel. It's not really the east, but close. They use that now to get out to the bike path. People go through there all the time. There is a way to get from there over to Northern Ave. People will get to know each other by walking, because that is a walking neighborhood. And I really feel like it's the kind of place where people who are interested in coming to Northampton or live here now would want to live.
I'm sorry, Karen, I'm staring over your head. But does the walking trail go, it goes between lots, between buildings 21 and 20 and 19?
Yes.
Not around them?
That's correct. We had another plan. I mean, if you look at the other plan, you'll see that the sidewalk went up the far right side of the drawing there, through the middle. It just struck us as a little less, neither of them send you directly across to the other units, but the one on the left, D, just struck us as a more interesting and attractive way to get from one area to the other. If I didn't care so much about keeping that open space in the middle between those rows of units contiguous, and here I'm referring to that area there, and these 2 rows of units here, I would just take the sidewalk and go up through here. But in the end, I ended up feeling like that was probably more intrusive in people's yards, and it didn't really connect the people in a way that was appreciably better. If you were trying somehow, if that was the only sidewalk out over here, and you had to get up, or get up this way to get there quickly, that might be a different story. But you have 2 sidewalks shown, one on each of the 2 exits. And I don't think anybody who's going up there is going up there for anything other than either to get to the bike path or to see their neighbors.
I guess that's in terms of the density, 20 and 21 are the ones that are most kind of separated from everything else. They're the ones, because the path goes between them.
Right.
No parking at them. They're almost, just dropped. If there's a space for them, so they're there. So that's, in terms of density, that's, I think, That was one of the things I was saying.
I was sitting
Yeah. Kathy?
I guess I was confused, I want, maybe you could explain it, Doug, this whole issue of the high water table and, water in basements, which is coming a lot from the neighborhood comments, and how the construction of these buildings would really deal with that. We have a note here that says construction will be slab on grade and not intercept the water table. Construction in an area with high groundwater does not raise the water table, won't increase the water in the basement, etc. So could you sort of
Are you,
explain?
I'm not sure what you're reading from.
This is something.
There's just staff comments
Yeah.
regarding that note.
Yeah, I'm gonna let Mark say something on this, but I can only say that the slope of the site is towards the wetlands. It is where the units are. The only place that slopes away from the wetlands are the two roads in. They slope out towards North Street. Hydrology dictates that water tends to run downhill. There are wet basements throughout the area. There's no question about that. The notion that putting in slabs here is necessarily going to create a worse condition for somebody is one that I can't really speak to because I don't have any expertise and don't really understand the logic being expressed. So.
Yeah, from the hydrology perspective, the site has areas of high groundwater. There's also areas where the groundwater is down a fair distance as well. Putting the slab on top of the ground really does not make a difference on the groundwater underneath. The groundwater is based upon the amount of water that lands on it and what flows underneath it. Putting the structure on top of the ground doesn't squish that water and make it go away. The stormwater standards that the state has developed, DEP has developed, and the town of, the city of Northampton has developed, require you to address all these items, realizing the amount of rainfall that falls on the site is going to be the same tomorrow as it is today. So the total volume of water that lands on the site is going to be the same. Removing some trees, obviously that makes a difference. The amount of runoff, surface runoff, will be different because of the pavement. And actually one of the requirements of the stormwater requirements are that you actually want to grab some of that surface water and they make you recharge that water. And there's specific quantities and volumes and methodologies that you have to follow. We've done an extensive amount of test pits out there to quantify what the subsurface conditions are and to make sure we're compliant with all the design requirements. Again, it's been reviewed thoroughly by the city engineer, and complies with all the current design for stormwater management, and that includes water quality, water volume, and peak runoffs to ensure there's no flooding downstream or adverse impacts. So it's been thoroughly reviewed, and whatever modified plan we come up with, we will have to comply with those standards again.
We have no basements in these units.
Yeah, and the no basements. The fact that other people have water in the basements is because they built their houses in areas of high groundwater, but their basements below groundwater. These units are not proposing to put any floors below groundwater. In today's technology, you dig holes. In the old days, you used to dig a hole, look down there and saw where the groundwater was, and say that's where the groundwater is. Today, you actually have to read the soil morphology. You look at a hole, it can be dry, but an experienced eye, you can tell exactly where the maximum high groundwater elevation is. And based upon that, we don't build houses below that elevation and make sure that our design doesn't impact that groundwater.
So just to follow up, I was there recently and you've been in there with a big piece of equipment, I guess to do new test pits.
Yes.
So why did you need to go in there again?
Okay.
I'll follow that up. We did exploratory test pits throughout the site to get an idea of what the subsurface looked like and what the groundwater elevations were. So we had a really good idea. When we finally massaged the plan to where we felt exactly where we knew where the detention basin and rain gardens were, by code, by state stormwater management requirements, you have to dig test pits in exactly those locations. So when we actually finally figured out exactly where those locations were, we had to go back out and dig holes in exactly those locations to 100% confirm what the subsurface conditions were in those stormwater management structures.
And with the new plan, there's not that much that's changed really in terms of the location of the units, but we're going to have to make a short trip back again to get a little more information.
speak to the groundwater issue. We know there's a flood damage report at 8 View Avenue from 1999. So it's a live issue on the site, and 8 View Avenue is a higher elevation than almost anything else that's being proposed to build. So I've been asking for more investigation of that data point as well. I hope it happens.
Any other comments from the board on the plan?
Well, you know, I'd just like to say, and it's one of those great ones, I'm of two minds. One of them, I think it's a great example and an attempt to do something that really lines up with the sustainability plan around infill and smaller units and providing a mixture of units that might allow for very different, less consumptive lifestyles. I understand about not having storage here and there, and but maybe if it's marketed, as Marilyn mentioned, as more kind of like they did co-housing, almost intentional. You're looking for those kind of people who are looking for more sustainable lifestyle. That might fit into this much smaller footprint. So hopefully then you're getting less car traffic, less impact on the environment. So in that one part of my mind said this is a great thing for Northampton and a great example of where we could be going. But on the second side, I'm very cognizant of just how fragile this area is, and being out there today and seeing what the machines have done, and just knowing that area and the mature stand of trees that will be gone. Part of me doesn't want to go too far down this road until the CONSCOM really does make their decision about some of these areas. I mean, we have given them some feedback about some of the issues that concern us, but this is a place where I think I would rather see the CONSCOM take the lead. I'll fall back on that old chestnut.
Well, what's the, Carol, do you know what the next, are they going to the next CONSCOM meeting?
I think they've formally withdrawn, and the Conservation Commission approved the withdrawal without prejudice, or I guess it doesn't matter really, you can refile. So essentially, the process will start all over again in front of the Conservation Commission, right? So to refile plans, and then Conservation Commission, start that procedure, the whole public hearing process starts again, so it's a brand new open public hearing.
But not for us,
Yes.
but not for us.
No, it doesn't have anything to do with the planning board. So you all could, continue this public hearing. I don't know if Doug has an idea about when he's gonna file, and to make a determination about whether it makes sense to close this out and then refile after you refile.
I wouldn't suggest we close it out per se. We may, as we get further into this, want to renotice it simply to be, make sure everybody's aware of it. But I think from the feedback here, the plan was to go back, get something to the Conservation Commission as quickly as we can, so that we're refiling with them, and presumably they would act before we're asking you for a final action. I think at this point we've probably got one more meeting of getting you the details back and getting it as close as we can, and then letting the CONCOM. Yeah, I always assumed the CONCOM was the one who was going first on this. So, George, I accept that as a given process-wise. So I wouldn't want to force the issue forward any faster than they're ready.
So if there's gonna be a continuation, you wanna do it, a couple months
So
out.
I was going to say 6 weeks is what I thought. I wouldn't go too much more than that. I think
You'd have to
we have to
then
go to
file.
CONCOM at 4 weeks or 6 weeks do we need to get there?
Well, the earliest you could go back to Conservation Commission would be April 23rd, and that would be if you filed tomorrow. So,
Unlikely.
probably the first hearing would be early May with Conservation Commission, is what I'm guessing.
So second meeting
So-
in May, or would we want
Right.
to be ready?
And you might want to
That's
even
8
put it
weeks.
to June, first meeting in June or something. But you'd want to make sure, I don't know if everybody has their schedule for late May, early June.
Can I ask a question also? I'm wondering if, the Concom's obviously the most important, but what about getting feedback from the fire department and the police department and the ambulance?
That's part of all of that information would feed into you as a board, and you would be taking those comments and making an assessment based on their recommendations.
I mean, I like this concept D, I like the open spaces, and I like the pedestrian stuff and all, but it's, you know, it is a real concern. But how would a fire truck get in and out of there? And I'd like to know what the fire department thought.
And it sounded too that, I think maybe you need to clarify that your intention was to have two separate named streets, so it would be almost as though, in terms of addressing for fire safety, that may ease the complication from emergency response perspective. You know, they have different street names and then
They don't have to
unit
turn
numbers.
around though? They have big truck.
Would they,
They, you know,
turning
they,
around isn't, I mean, turning around once every 15 years, the need to do that, if they can back out, or whatever it's really getting to it is the bigger issue. I mean, yes, it's convenient and it's nice for them to be able to turn around, but they can't turn around
They
in
have
a
to
lot
be
of
able,
situations.
I mean,
they
when
have to
they,
be able to
yeah.
turn the corners.
Yeah.
Right, that's
Yeah.
more to the point. I mean,
Yeah.
Northern Ave, they
Without
get to the end, they're
car
not gonna turn around there.
Right.
Nor are they on Woodbine or many other streets in
Without
town.
car obstruction too.
Yeah, it's hard for me to favor one plan over the other for the same, if that's the problem you have.
So it sounds like you all would want to understand the feedback from fire department before you favor one.
Another emergency meeting.
Well, let's presume for the moment, and you have to, I'm walking in with the presumption that I can get an okay from those folks, because if I can't, obviously it's back to the drawing board. But presuming I would get an okay, under that context, I would be asking for what your preferences were. And in your case, I seem to hear that you preferred D.
I like the open space, the green, I like the pedestrian walks. And, you know, I sort of agree with what George is saying, or maybe it's Marilyn, that.
I'd go with D also.
Okay.
These are nice.
And it sounds like it's at least worth a shot, which is take it to the fire department, you know, resolve the garbage issue, start dealing with all of, frankly, there are lots of issues, lighting, there are a million things we haven't really begun to look at yet. But, you know, get into the stormwater, that's really the big one, is that we just did a stormwater on something very close to L, and we got our permit on that, so we're gonna go back and we're gonna do that again. And I didn't want to frankly put Doug McDonald through that if your feedback had been, D doesn't really help us at all, we really like L. And I'm hearing that you probably, if the rest of the world is equal, D is probably the way to go.
Or,
And if
just to further that, I guess it seems like you like D better, or I like D better than L. I like L better than what we saw in January, so it seems like we're trending in the right direction. But, and just the things that we talked about, potential issues with, you know, I'd like to see the next iteration at least touch on the traffic mitigation, trash removal, snow removal, storage, fire access. And then the only other thing I have is those units at the bottom, 10 through 14, the site slopes to the wetlands, but it also kind of goes down. And those units, they just kind of trouble me. No parking, I mean, no garage, they're off by themselves, there's no storage, and they're at, it seems to be like at the low end of the totem pole.
It's actually pretty, we've got it pretty flattened out there in terms of the topo. It's not, they're not way downhill at all.
Okay.
It's, if you know, the topo is not meant to show up very well on this plan right now. It wasn't meant to, we have other plans we're gonna put out for you that have the grading much more prominent, the utilities clear, those kinds of things, frankly, we weren't even interested in trying to show you as much during this first brush at it.
Okay.
So I understand your concern.
The developers always try to maximize their space in their units for what the return can be. Right now, there are 21 units, I think as was mentioned, maybe.
23 including the two on Northern.
20, yeah, okay, 23. So maybe 20 and 21 and 13 and 14, to my eyes, might help also to kind of bring the whole complex in and away from the wetlands and reduce some of the exacerbation to the neighborhood. I'm just making that a suggestion. I don't know where the rest of the board feels on it, but if we were to look for the applicant to reduce some of the capacity, those might be the units that I would suggest closer to the wetlands there.
I think 13 and 14 are more problematical than 20 and 21. And that parking lot is right up pretty close to those units. How would you even get out of those two last parking spaces? Someone has to back out into, that parking lot will fall.
13 and 14 on D?
On D, yeah.
You're not driving to 13 and 14, you're at the parking lot. You mean the parking lot where it's adjacent to 10?
I'm just saying it's very, very crowded in there. The parking lot, the units, and one of the things that I noticed is you get that parking lot full, to get out of those last two spaces, you need someplace to back to get out of there.
Yeah, there's some, I mean, we certainly could address that. It does meet your requirement. There is enough space between the rows to make it work. I mean, I'm sure that if the goal was to make every car have the easiest time, you wouldn't do that. But our feeling was frankly to keep the impervious area down.
Well, I think with Kenny and George, I think there's a few of us who, the density does, the number of units, it's a struggle a bit. And I think George has mentioned 20, 21, and 13, 14, I think Mark mentioned it. And so, yeah, I think that's I think, for some of us it is.
I mean, 13 and 14 are 50 feet from the wetlands.
Well, I guess I'm not saying necessarily 13 and 14, it's that whole area, just very crowded in there with the units and the parking. There's very little space in there. So what do you think?
In the front of 10 through 14?
What's that?
The front of 10 through 14, you don't find that space? I mean, it's no more units than we had there in the first drawing. It's the same number. It was just the goal was to get them away from the wetlands and in fact not to bring the parking out to all of the units, to have fewer garages and more of a clustered parking approach.
Those could be the nicest ones.
That's what we were just saying.
Well, that's why
Because
it's,
they're empty, they have the paths, they're more private.
Yeah.
well, then I think, but regardless of which
Yeah.
individual people feel, I think enough of us have a concern about the number of units. So whether it's 13, 14, for me it was 20, 21, but that's, I think you're hearing what we're saying.
Sure. Let me just, I mean, I keep speaking to why we could talk about 13 and 14. Clearly the question for 14, for example, is, well, there's a decision about where the detention pond is, and as you pull that unit away, you get a little more land for open space in the front of it, and so that's a trade-off. And going at 20 to 21, I felt like that was actually a nice bookend to the project. The fronts face towards the field that's out there, and the path tends to connect it to the rest of the project. So I didn't end up feeling like those were lost in space. Originally, they were lined up in the same row with the adjacent units, 15 through 20 or 19 there? Yeah. And I changed that for a couple of reasons, but one of them was it just felt a little bit more like things were looking towards the same center, and it also gave them kind of a nice private backyard, the way they worked out. I mean, I understand that there is always a tension with density. I have a natural, it's more than my typical tendency to resist that here. And part of it is that unlike when I go to some other part of town where I'm used to having that discussion and used to seeing units reduced as part of the process, I reduced it a little here, and certainly I could show more units and I could show less units. I can make it work either way. I just felt like it was not uncomfortable, that the place is not going to be uncomfortable, and that it was in some ways the fact that I had taken two pieces of, this is two pieces of land owned by separate companies put together, and they came on the market, and it made the project bigger, and somehow that makes it more politically difficult to deal with. But it's good planning to try to put land together and make it work together. So, it's a bit of a catch-22 for me, the way I'm looking at it.
Was there any discussion, anybody have any questions about, I can't remember, because it's been a while, were you building LEED certified, or was there?
Yes.
Yes.
Can I just ask for clarity, you said you dropped some of the garages, but how many units now left have garages?
I believe it's 8. Yeah, sometimes you'll see a parking space in front of a unit, but that's just one parking space in front of the unit. And there'll be another one elsewhere. Only the large ones, the ones that are deeper, are the ones that have garages. And they also have to be connected to a road, so that gets you down to 8. I'm sorry, no, that's not right. Up at Northern Ave, there's one more, 9. There it is. I keep forgetting those two.
I just think it
There are
would
9.
probably be important for the board to think about, there was a comment about extraneous things that people may collect and want to just throw outside or throw in the garage and garbage, but, when people, the sustainability plan and the comments that we heard throughout was creating a diversity of units and creating smaller units, and the more structures you build for smaller units, they start to be less affordable the more you're adding on to it, and the whole idea about creating smaller spaces for people who don't need all that space. You all should probably keep that in mind in the context of that diversity of units, and people probably tend to live within their means, I would think, and you could also create rooms inside units for recycling facilities and garbage. So I don't know that, I would hate to have, let's say units taken off just to create garage spaces for people's garbage because they don't want to see it and handle it internally. And the more recycling we do, we're not going to have maybe 10 bags of garbage every week. So just want to throw that out there.
People who live in apartments have the same problem.
Right.
And a week's worth of garbage is not normally overwhelming amount of garbage. This is the winter side of the year.
Well, you can also take your own garbage anytime you want to the DPW. Yeah.
I thought that the presentation on the density, that I felt that the density was not unreasonable in terms of the analysis. The aerial views, it's pretty consistent. I don't think it's outrageous at all.
I would agree with that.
That's why you come to us, because consensus.
I think I'm encouraging, listen, part of what happened at Conservation is that some things came up after the hearing was closed that were pretty out of range of what I had expected and what had ever been discussed. And I want to make sure, frankly, with all the situations that Northampton has had with public process, that we at least do the best to talk about as many things here as we can think of in as informal and creative a way as we can to get to the best solution.
Were there any other questions or any other comments?
I think just when we see another plan, if that day comes, that there's more detail about buffers with some of the existing homes, especially where we're losing all that trees, even though I realize the trees now, the tree stands are so big, there's not really a site buffer there as much. But I think with the car traffic, you'll need that for the headlights at night and whatnot, so some thought put into that.
Okay.
Was the first meeting in June, or was it the last meeting in May?
Can I suggest we go, just go 6 weeks, and if I can't make it, we'll continue it, because I had a hunch. Or go 8 weeks, rather, I'm sorry, 8 weeks. The last one, the second one in May. Yeah.
Given all the changes that we've seen, and you're going to go through some more changes, wouldn't it make more sense to perhaps withdraw this application without any prejudice and provide him with the applicant a waiver, not to have to submit another application fee, and just start over from scratch?
I don't
Yeah,
care either way.
Huh?
Carolyn,
Well, I've been.
I don't know what the difference would be versus what we're doing.
I think the only difference would be the
Well,
makeup
there's-
of the board, and that's not really gonna change.
Well, there's comments from the DPW from the first time and the second time. There's comments from staff on the first one and the second one. We're getting new iterations of everything.
You mean the
Comments.
file is gonna get pretty
feedback.
full of stuff that's irrelevant?
Well, it is tough to keep track of where to go. It's not as big as the state hospital, but I'm losing track of a couple of things.
I think that the board could go either way. I think the benefit of, there could be benefits either way. The benefit to the applicant for continuing is it doesn't, the process isn't quite as long. We require, and there's the filing fee.
What? So we can waive that. I think we've done that in the past.
Yeah, but, you know, we also, I'm not sure that it would gain much. The only other issue would be finding a date that everyone knows that they're available, but that could be a problem with refiling as well, because you're not all, you know, I think it could go either way, but it probably takes a little bit less time, and ultimately, unless you waive the fees, which,
Okay.
is possible, then it isn't going to be that much of a difference.
So what's the date you make?
You know, half the reason I wanted to go with the notion of continuing is because, first of all, I can always let Adam know if it's gonna be continued, because he's as good as anybody at getting the word out. And I'm good to my word on that. I'm not gonna suddenly have a hearing when I say I'm gonna ask for a continuance. But my concern is, since you don't know when you're gonna be back, who knows what, we could end up having to continue it again when we get there. So I was worried about going into June, so I think probably the last weekend in May, or the last meeting in May.
28, wait a minute, 14, 28 is would be the meeting date.
I'm not gonna be fine.
So 14th, there's the 14th and the 28th are
We all have to do this seven.
Well, if you miss one, because of the situation, you won't be able to vote on the final. The 14th of May?
the calendar's wrong.
What?
This Memorial Day is the 31st.
No.
No, Memorial Day is the 25th.
I know, can you believe it?
Yeah, I'll be here on the
It's
14th,
just-
California.
14th, anybody else have a
So
problem?
when are the meetings in May? The
14th and the
14th and
28th.
28th. Or if you feel comfortable with May 14th, or is that too soon, we could do it.
That's fine, one way or another, I'm gonna deal with it.
Is that assuming that your trip to the Conscom is only gonna take one meeting?
We don't have,
It could take one meeting, and I would expect it would take two.
That gives them
But
extra
I
time.
also think that that we could get a lot done without voting again. If I got to vote at the next meeting, I'd be shocked from
Right,
you
but
folks.
the
And I don't
first
mean that as
meeting-
any disparaging statement, it's just a fact.
So are you planning
Wait,
to go to April 23rd to Conservation
I don't think we can make it.
So then that's May 14th.
Yeah, I
here,
know.
So that doesn't make sense. So then we're June, because Maryland, you
When
can't
you
make
say it doesn't make sense to have, we would have final plans, we'd have DPW stormwater report permit.
You won't?
The question is, could we vote? And the answer is, I wouldn't want you to vote. But I think that there's more than one meeting's worth of, I think that
So
we're
you're
gonna give
saying
you a
you would
plan,
be-
we're gonna get some more feedback, and we're gonna get to, hopefully at that point, get to a plan that we can bring you in June that would be a final plan.
Well, maybe we don't do May 14th with us. If you think you're going to Conscom, more revisions, and then final plan in June, why not wait till June with us?
Right, I think that would probably make more sense instead of having two here, conservation
Yeah.
on May 14th and planning.
I'm not sure the Conservation Commission is gonna ask me to make revisions that would be beyond and above what we've discussed tonight, other than things which would probably not be relevant to your plans. I have a hunch that we may have finally found
Well, we could,
I could be wrong, listen, if you wanna go to June 14th, is that what it is, June 10th, June 14th, 11th?
Doug's risk.
I mean, we could, yeah.
If we can
push
get
on the
everybody
14th
here,
of May.
all right.
It's your writ, yeah, that's,
No.
let's do the 14th of May.
Put him on into the summer, and,
Right.
certainly I'm gonna be available.
All right, so
So
we'll,
put him on the 14th.
It's hard to believe we're at the end of March. We'll
Make a motion.
You wanna do it at 7?
Grant continuation of the hearing, so we'll be May 14th.
June.
Why are we doing it May the same day as he's going to Conscom? Well, we're not gonna have any input back from them, he's assuming that it's all gonna look good, so. Then we'll continue it for May.
Right, you'll get more feedback like tonight,
Uh,
so that when he comes in June, it's a vote meeting, not a
we're gonna see
discussion.
we're gonna see final plan for May 14th, or at least the final plans you're submitting to Conscom. So, no, his,
But George's, the whole issue of Conscom really, they need to like
right,
it.
I think we all, I
Right,
mean,
right.
we're in agreement that Conscom has to, we're not gonna approve it until we get
Until they do.
Conscom.
Well, I think we have to have a clear feeling that he was on the right track.
Well, let's see how it looks on the 15th. I mean, I think we got a motion, do we have a second for the 15th? Second, all right, so we got a motion and a second to continue to 7 PM. Carolyn's computer's going crazy. On the 14th. All in favor? Opposed? All right, unanimous.
Consensus.
All right, see you on
May 14th.
May 14th. The last item on the agenda was for 9 PM.
Not bad, not bad.
Anesthesia leadership.
I know.
A request by Hospital Hill LLC for definitive subdivision approval on the north campus of the village of Hospital Hill, Moser Street Extension, located on Village Hill Road, map ID 31C-17 Northampton. They're asking for an extension.
Right, so, you got it.
Yeah, why? That looks like an easy.
Just let her speak. Please, Greg.
As you know from staff report, there were a couple of issues. One was the biggest issue was relative to DPW's concern with the sewer depth. And DPW and staff and Mass Development met and couldn't come to agreement about how that would be handled. So there's been a lot of discussion about that, but today they decided they needed more time to think about the solution to basically the 10-foot sewer depth. There were a couple other issues that we could have worked out before, but the sewer depth was a big technical issue that could be together. So they've asked for continuation so they can think more about how they might address the sewer depth.
Do they have a date?
They wanted to come back first meeting in April, which is going to be April 23rd, because you're not meeting the next April 9th.
We're not meeting with.
Why not pass it? You can have it right over there.
So you want a motion for, is it 7 PM? Do you have anything else?
Oh, wait, let me just look.
April 9th. So when are we meeting?
Committee is scheduled there.
23rd.
Week after. But it's difficult for us to do that, because that's the city council.
Oh, right.
Yeah, there's nothing, so, there's nothing that will have a permit, but we put that first step. It shouldn't, if they deal with this issue, it really shouldn't be, a long trip.
If you don't,
Oh, no way, girl. That's what I keep saying, a quick Hospital Hill?
We should really, before then, all take a walk up there together. It's pretty confusing.
Let's do that.
Yeah.
We should really go up there and look to see how those streets lay out and what's what. I went up there a little while ago and it took me a long time to get my head on straight, which I know is not a surprise, but it would be great to do a site
A
visit.
group site visit?
Yeah.
Do we want someone from
those
Mass
new
Development, or do we want-
townhouses are pretty neat.
Oh, they're great.
Do we want somebody from, just us, or do you want somebody from Mass Development to walk around?
No, I don't need.
No, we don't want to.
Okay, so just us?
Yeah.
Okay. Well, I can send an email out and try to pick a date.
Yeah, yeah. That'd be great.
Yeah.
If one of you guys are. budget
Friday.
meetings.
Yeah.
All right, so we need a motion to continue to April 23rd.
I'll make a motion to grant the request for continuation to April 23rd at 7 p.m.
Yeah. Yep. Thank you. All in favor?
Aye.
I'll make a motion that we adjourn.
All in favor?
I beat ya.